Item 12. May ako ba? Sarse. Yun. May ako sa wala ko link up na wrong here.
Serious objection.
Okay, we'll first we'll see why, for what purpose it is listed today.
Yes.
My lordship, I beg to mention item number 16.
Yes,
The conducting council is out of station. I have taken the consent from the opposite council.
paper book.
It's a
2020 matter, conducting counsel for whom?
R. Sunar.
These are all matters, criminal matters. You are behind the bars.
Yes,
Why are you seeking time?
because the conducting council is out of station.
Should make it, the urgency is yours. Client is behind the bars for the last 5 years, 6 years.
Yes. Your Honor, which may please after 3 weeks.
A prayer for adjournment has been made on behalf of Sri R. Sonar, learned counsel for the appellant. Also heard. Who's for the PP? Anyone? PP? Which PP is present in the court today? Mr. Ratan? PP? Also heard. Reasons learned additional PP and Miss Anne Dungan, learned legal aid counsel for the respondent number 2. Para? Considering that this appeal is an open one, while adjournment is granted, the same is directed to be listed for hearing on
After 3 weeks.
after?
3 weeks.
3
2
weeks.
2 weeks, 2 weeks.
No, not 2 weeks.
Not okay.
When is he coming back? We fix a date. 2020 matter, criminal appeal. Otherwise, we'll appoint an amicus curiae. Cannot afford like this. Give a date.
Just a second.
Date, huh? Date. We'll give a date. Okay. We'll give a date, madam.
May I please your lordship, my lord? I'm online, my lord. Item number
Yes.
12, my lord. I'm on behalf of the petitioner.
Just a minute, Mr. Purkasta, 1 minute. Yes, we visit it.
February kung full doon na March na kapal lagi.
Today is 10th. We'll have 17th,
17 February.
17th February, next Tuesday.
Okay.
17th February.
Lordship, can it be on 18?
See, I've been told that division bench is Tuesday and Thursday.
Tuesday and Thursday.
We'll have it on a Tuesday or Thursday.
In that case, 19, Lordship.
19th,
Yes.
19. Okay.
19 too.
Much.
Yes, Mr. Pukasta, which matter?
I am, my lord, item number I am in respect of item number 12. I have been
12,
told the
yes.
Standing Council of Education, they are going to take time, my lord, to file affidavit. My only anxiety is that, my lord, they are regularly they are taking time. So lordship may
Let
be
it reach,
pleased to
let it, they have not given, made the prayer, let it reach.
my lord.
Yes.
Item number 1. 1 and 2.
Your Lordship, here I am representing the petitioner, Your Lordship. And Your Lordship, I have submitted my wakalatnama before the registry.
So when can we have this? Next Monday?
After 2 weeks, Your Lordship.
It's for motion.
Yes, Your Lordship. I have
2
to
weeks.
I have-
Next
not received the brief also yet.
Monday. You have to collect the papers. 24 matter for motion.
Your Lordship.
We are in 2026, yet to be moved.
Yes, Your Lordship.
Next Monday. What
Your
is your
Lordship.
name?
El Tatam. El Tatam.
Lord-
L-
Lordship, AG will be appearing in this case, Your Lordship. He will be here on 23rd or 24th,
It's for motion.
Lordship.
We'll issue notice and fix on a date when AG will be there.
Lordship.
Okay.
Your Lordship, at least 2 weeks may be given, Your Lordship. I pray.
You have already entered appearance. You need the
Yes.
papers you take from the court. How long do you need? You have to move it. 24 matter, we're not granting 2 weeks time for that at the motion stage.
Your
Okay.
Lordship, I'm from the item number 2.
Yes.
Yesterday, it was told that today we are supposed to take the decision, not then we'll segregate the matters.
Hmm.
So if
There's
possible,
no requirement. There's a council appearing. Okay.
okay.
Sri so-and-so, huh? Planet Council has submitted that he has entered appearance for the petitioner in PIL 18 of 2024. Full stop. Also heard Miss Basar, the learned State Council. Full stop. The petitioner in WPC, in the connected WPC 136 of 2021 is represented by Miss, what is your name?
M. Jarang, Meenakshi
M.
Jarang.
Jairam. Please give your name, okay? Para, please, for motion on Monday next.
Okay.
Monday is a DB day. No, not Monday. Tuesdays and Thursdays,
Yes.
on Tuesday.
17.
17th.
Lordship, then on 18.
18th is Wednesday. We've been told that Tuesdays and Thursdays are DB day.
Then on 19, Your Lordship.
19th,
19th.
okay, 19th. In that case, let it be on 23rd when AG will be there.
Lordship.
23rd.
Lordship.
Okay, you also get more time.
Much obliged.
Item number 4. Item number 4 to 6.
Wait, please, Your Lordship. Before my learned senior starts, item number 4, my lord, there is a new additional affidavit in file yesterday, bringing on record some file notings to show that the vacancy positions that were not before his lordship in the proceedings to show different vacancy positions. I need to respond to that. I have instructions that the vacancy position that been shown in the file notings were against officiating anticipated vacancies.
It has been filed yesterday
Yesterday, madam.
by Mr. Mazumdar.
No,
No, I have filed my lord.
and that is not even complete.
No, my lord. I will not rely on those, my lord, additional document, my lord. I have filed only to show that, my lord. Even, my lord, after examining this, there is a vacancy, my lord. The department has, my lord, identified the vacancies only to show this, my lord. And we rely totally on the, my lord, materials which were before the, my lord.
If they don't rely on the additional affidavit, very well, my lord.
Matter is very short, 15-20 minutes I will complete.
But that
Only to
may
see, my
just
lord,
not be
whether
looked into, my lord.
at the point of giving officiating promotion to us, my lord, whether there is a vacancy or not, my lord.
No, my lord, my instructions said that there were no vacancies because the earlier record says no vacancies. Now this vacancy that has been noted in the file noting,
If we take this matter for consideration,
Yes.
whole how,
Right.
then if the additional affidavit is filed yesterday,
yes,
That will not be taken.
and if they are making an undertaking, given undertaking that will not be relied upon, then you
Yes.
can go ahead.
yes,
Yes, yes.
But if
if-
go ahead,
Hmm.
you will not look into that
Yes,
affidavit.
yes, very well.
Yes, no?
Mm.
My lord,
You take a call.
my lord.
Yes, ma'am.
If you are relying on the affidavit, then we'll have to give Mr. Panging a chance.
My lord, I will not rely on.
And then we'll rely upon the materials which were before the honorable single judge.
Yes.
That's all.
Short matter, man. What would? I don't know.
yeah,
My lord, item 4, 5 and 6 are, my lord, connected matters, my lord. My lord, 4 and 5 arising out of, my lord, same judgment, my lord. However, my lord, in 5, my senior counsel appears, my lord, so he will lead the, my lord, the proceeding, my lord.
How many matters are there?
3 matters, my lord.
3 appeals are there
Yes.
against a common judgment.
No.
At number 6, my lord, judgment will discuss. But issue is set.
Issue is the same,
4 and 5, again the same judgment.
same judgment.
6 is dismissed on the basis of judgment rendered in 4 and 5, my lord.
Okay.
Consequent.
What is the judgment dated?
Judgment is of, my lord, 31/8/2024.
Judgment dated?
31st August 2024.
Okay, you want us to have which file?
Item 5, man.
35?
My detail number to
Santosh,
detail 356, man.
please give 35.
356 लिखा है और देखो देखिए इसको पूरा 35 है 35 होगा 35 हो 35 में itu লাইছে না
আপনার 3টা দিলে দিন
এর মুক্ত থাকো তোমাকে ফটো দিয়ে
We are taking 35.
35 this should be the photo
Yes, which page? You want us to read the judgment?
Madam, I have prepared a short 2-page list of dates. From there, Madam, your lordship will kindly get the background.
This is for us. I think this you have prepared.
No, just now there is some mistake there. Yeah. You have copy. Basically, the petitioners who are the appellants before your lordship, they prayed for a retrospective promotion to the post of assistant engineer.
You are the petitioners.
My lord.
Appellants were the petitioners.
My lord.
How many appellants? 6.
There were initially 7, but one has, on his own volition, deleted his name.
In the
So-
proceeding itself.
Yes, ma'am. So there are 6 now.
No, not in the appellate stage.
No,
In the proceeding stage, was he there? or
that
not?
is retable 4, my lord.
Hmm?
There, he has filed a separate retable. There is retable
No,
item.
understood.
Yes.
We are in the proceeding stage.
Yeah.
How many were there? 6.
7. Retable number.
Retable 7.
Petitioner. But in the read petition, there were 7. Appellate stage, he has.
6. One has filed separately.
My-
Okay, doesn't matter. 6 has filed 35 of 24 and 1 has filed.
28, I think, my lord. I see.
28 of 2014, man.
20.
Mr. Sakya is
My-
appearing. Okay.
Lord, will you kindly take up this list of dates I have furnished today,
Hmm.
man. Appellants who were initially appointed as JE, Junior Engineer Electrical, in the Department of Power, Arunachal Pradesh during the year 1994-97, became eligible for promotion to the post of assistant engineer on completion of qualifying service of 8 years. It should be 5 years because all are degree holders, my lord. And the department also had the need to fill up.
Yes, you have prepared. We cannot correct it.
My lord, I'll show from the records, my lord. There's some typing error. It should be 5. But subsequently, I have clarified, my lord. Became eligible for promotion for the post of assistant engineer on completion of qualifying service of so many years. And the department also had the need to fill up the post of AEs, but due to non-holding of DPC, they were promoted on officiating basis to the post of AEs during the year from 2008 to 2011. Subsequently, they were given regular promotion in the year 2022, but with prospective effect. By filing the writ petition, they claimed retrospective promotion, which was dismissed on the ground that there were no vacancies, hence this writ appeal. And the whole writ appeal, the almost
But don't you think that our decision rendered yesterday would cover this issue?
more or less covered, my lord, but
Because we have not
in
only
that-
said that it will be confined to those petitioners with enlarged the field.
Lord,
Anyone aggrieved can, because this new committee,
my lord,
which was formed on 37/2025, I think.
yes,
Was the date?
in that
30
case, yes.
13/7 or 37.
Yes, ma'am.
So we have said that.
More or
all-
less, the lordship is correct to point out, my lord, how they should take it
No,
forward.
instead of our entering into the merits,
My lord.
Mr. Pangi, where is he?
He just went out, Your Lordship. He had some.
And I'll just point out,
No, we'll hear you. And who's for the government? Here for the department. Mr. Pangi, we have just realized that the issue would be covered by the decision which you have rendered yesterday. We have enlarged the field of scope of examination, not only confined to those appellants parties there. In the last side, that anyone who's aggrieved with this mechanism, the giving retrospective vacancies are there or not, because there.
Here, my lord, the file was processed, that has been rejected by the Honorable Chief Secretary. That is what I have been told. That is, I wanted to bring that on record on affidavit also.
No, this will be relevant consideration for the committee.
But my lord, here I can show that they were against direct recruit quota.
Huh?
They were against direct recruit quota. Promotion was against direct recruit quota.
my lord will give me 50 minutes. I'll just point out the relevant
They
things
are not
only.
promotees.
Their promotees, their officiating promotion was against direct recruit quota. It is there in the order
These
itself.
are again matters within the realm of consideration of the committee.
But my lord, here,
Direct recruit, vacancy.
no, that committee is only for that department. There was a subcommittee here, my lord. I have hit here.
No, aren't you talking about this hydropower department?
This is
No, man.
This is what department?
This is,
power, my lord.
yes, they're different departments.
That committee is for
No,
hydropower?
yes, that is only for that.
Only for hydropower?
Yes,
Okay, this is the original.
original department, parent department.
Here, there is no committee for examination.
Not yet, my lord.
There was
Because
a committee, my lord.
directs,
Hmm.
But
But
this was
presently,
not,
there is no committee which is,
there was a subcommittee after the judgment passed by the learned single judge. They have now decided to go implement the judgment of learned single judge. The final seniority list also was issued around 4 days back.
okay. Oh, this is
Yes.
on a different.
Different.
And if your lordship directs that, if I can point out. and
Otherwise, these
satisfy your
things, man,
lordship.
I could have brought on record. In the additional affidavit, that says so many things. If that is not being considered, it's another thing
My lord,
also.
they are not relying on the direction. Let me point out just relevant things and nothing else, my lord.
Specific presentation. Specific presentation.
Regarding. Yes.
I'll take 15 to 20 minutes. I'll finish the entire my lord. Kindly see. This serial number 2, my lord. 1994 to 97, the appellants were initially appointed as JE. And then 2008 to 2011, they were promoted to the post of AE on officiating basis. Then 24/7 2012, as many as 11 AEs in the department who were senior to the appellants and were promoted to the post of AE on officiating basis during the year 2007 and 8 were recommended by the DPC for regulation with a retrospective effect from the date of officiating promotion. We have given an example. Then, for the purpose of aforesaid regulation, 8 posts of AEs meant for direct recruitment quota were convertible. This is not very relevant. Then next, advertisement issued for filling up 20 posts of AE by direct recruitment. Then 17/7/2013, appellants were reverted to the post of JE for the purpose of appointment of the respondent herein against direct recruitment quota. Then 18/7/2013, government appointed 20 AEs, including the respondent number 5 to 24, represented by my learned friend Mr. Panging Menon. Direct recruitment pursuant to the advertisement dated so and so. Appellants were reinstated. We were reinstated to the post of AE on officiating basis with effect from the date of their reversion, that is 17/7/2013 itself. Therefore, there was no break in their service as AE on officiating basis. Appellants have been representing from time to time for considering regulation of their officiating promotion with retrospective effect, but to no avail. In WPC number so and so filed by appellant 4, 5, and 6, this honorable court directed the respondent authorities to hold DPC within 4 months to consider the case, including other similarly situated persons. Then on 23/6/2022, appellants were promoted to the post of AE on regular basis on the recommendation of DPC, but with effect from the date of DPC, that is 10/6/2022. This is their grievance, my lord. Then the next page is the date on which the single judge has, my lord, disposed of the petition. Dismiss.
I'm sorry for interrupting the learned senior counsel. This is exactly what I need to respond. This was not their case in the
No, my lord,
petition.
I have given this not from my own, from the affidavit of the government.
That is why, my lord.
From the affidavit of the government filed before the almost single.
My instructions are that these were against anticipated vacancies. There were officiating promotions of executive engineers.
That is why what your lordship has indicated is necessary, because they will have to undertake an exercise to whether.
Before that,
My lord.
we'd like to have this factual position clarified by the department.
Department have filed a.
You might say that there were vacancies. Mr. Panging might say that there were no vacancies. It was anticipated in nature. This question of fact can be clarified only by the department.
My lord, department has clarified. Lordship will kindly see page 173. I have written here from their affidavit.
What have they said?
My lord, they have said this is what I have written, my lord. Lordship will kindly
The
see.
larger single judge has held, though there is a statement in the affidavit, it is no contrary to the records.
My lord, I'll show two things. One, this affidavit filed by the government, and second,
Parme? What about the vacancy position? It is hinges around that vacancy position. Learned single judge has negated their prayer only on the aspect that there were no vacancies.
yes, my lord.
Now, what do you say? Were there vacancies or not?
Our stand before a single judge, my lord, there were vacancy, my lord.
There were vacancies.
My lord. And even we tried for review DPC, my lord.
So if there were vacancies retrospective, why not?
My lord, we tried, my lord, for review DPC, my lord.
Mr.
But
Panging, if Mr. Parme is come from the government.
There are no vacancies, madam. That is what the
No.
government.
See, we cannot rely on a statement made by you, neither
Not my statement.
neither
I-
Mr. Mazumdar. So
I
far as
I can show from the record, my lord.
no, see, we cannot, what this standing council is saying,
May-
representing the department,
I understand.
his version we have to accept.
The learned single judge has said, except for mere statement in the affidavit, record proves contrary that there were no vacancies. That's what the learned single judge has said.
That is not correct. That is why we are here before your lordship, my lord. My lordship may kindly see page 187. I am showing
Mr.
from
Parme, do
the.
you have the records?
yes, my lord, I have the
Show us from the record, the vacancy position, matter ends there.
Yes.
Your statement made in the affidavit.
In our affidavit also, my lord, we try to specify that, my lord.
No, in the affidavit, you have said that vacancies were there.
My lord.
Kindly show from the records how vacancies are there.
No, there was nothing there in the affidavit. My lord, may I pray, my lord, will give me some time, so after, my lord, the learned signature is held in our favor. I may also be allowed to file an affidavit, my lord, to show this. This is 8 vacancies.
No, affidavit regarding what?
Not necessarily. My lord, I
Where is
will,
the appellate stage? There is no question of exchange of pleadings.
No, yes.
That is what they have done, my lord, that is why.
No, they are abandoning that.
yes.
If they were harping upon that, definitely would have given you a chance. Now, if they are making a statement in the bar that they are not relying upon that affidavit,
Well, can it be next week, my lord, so that at least by orders I can show that what they are stating here, that were vacancies in respect of officiating promotion of executive engineers. They were never regularly promoted in 2022 only.
Mr. Panging, just understand the perspective from where we are taking this matter. We can neither rely upon Mr. Mazumdar's statement regarding vacancy, we can nor rely upon your statement regarding vacancy.
My-
Other statements,
Based on record, my lord.
submissions are all, these are all factual aspects which can be clarified by none other but the departmental council.
My lord,
We have said that vacancies
my
are
lord,
there.
my lord,
I have
my lord, may I make, my lord, may I make one submission? Well, I'll show two documents. 2000, last, in the list of lists I have given, the last promotion was made by the department in 2012. There is an admitted position, my lord. Other side also cannot dispute this. Lordship may kindly have a look at page 109. Just two documents I'll show, my lord, then your lordship will, my lord, do whatever lordship has desired to. My lord, page 109 of this. 109.
First, let us see the affidavit.
Filed by, yes,
And number one,
Page-
what reasons have been cited by the
yes.
the single bench
My-
for not taking into
Lordship
consideration?
will kindly stay to a turn to page 187, government affidavit, relevant paragraph.
Yeah.
Page 187,
It's a part of the appeal?
part of the appeal, my lord. Page 187 of the memo of appeal. itself.
Yes, yes. Paragraph?
Paragraph, my lord, it is not numbering here. The first subparagraph, my lord,
Yes, therefore,
therefore, in terms of 50-50 ratio
yes.
for direct recruitment and promotion as per relevant recruitment rules, there were 14 vacant posts each for direct recruitment quota and promotion quota between the period 1/4/2008 to 31/2012.
Oh.
This is where it becomes relevant because the last promotion was made in 2012, which your lordship will for a moment find in page 109. There they have made the last promotion of 11 persons,
14 vacancies
my lord.
from 14808 to
31/12/2012.
and how many have been promoted?
11.
11. 3 were there.
No, my lord. Those 11 were filled up for against promotion against quota arising prior to 2008. Here is the crux, my lord, which the honorable single judge has missed, my lord. Before 2008, the vacancies arose and 11 vacancies were filled up. And government filed an affidavit saying that after 2008 till 2012, 36 more posts were vacant. Out of that, the next page, my page 188, the final calculation has been given showing that 14 posts were available for promotion. This is the only aspect in which, in my humble submission, honorable single judge
Please
is
come
missed.
again. You
My lord.
say that according to this affidavit,
My lord.
for the period 1/4/2008 to 31/12/2012,
There were 36 posts.
there were
36 posts.
14 vacancies.
No, my lord, 36 posts here. Total 36.
Hmm.
And then
Vacancies.
total 36 vacancies. And then backlog for direct recruitment were 8. So from these 36, 8 were deducted. So now the available posts become 28. Next page, Lord, should kindly see, considering the 50-50 ratio, 14 posts each. That means for direct recruitment 14 and for promotion 14. Now 8 posts were initially deducted because earlier direct recruit quota was exhausted for promotion. So that has been added. Now from for the direct recruitment, there is 22 posts available for direct recruitment. Next page, my lord. And so far as promotion quota is concerned, where we can be accommodated, there are only 14. And we can be accommodated against this. This is what our submission is. Now, let's just for a moment see page 109 here. Admittedly, the last promotion was made in 2012 of 11 persons. Lordship will see 24/7/2012 DPC. A DPC comprising the following composition met in the office chamber of the Chief Secretary on so-and-so to consider the regulation of officiating promotion of 11 AEs. Name has been given. The DPC was informed that in the year 2008, based on a representation submitted by APST graduate engineers, the state government had accorded one-time relaxation for conversion of 8 posts of AEs meant for direct recruitment quota to promotion quota by order number so-and-so dated 17/2008. Accordingly, the department had considered officiating promotion of 8 AEs, namely so-and-so, so-and-so. Prior to that, department had also given officiating promotion to 3 JEs, namely so-and-so, so-and-so. The DPC have scrutinized the ACRs of violence, vigilance, clearance, etc., etc. All the A's appointed on officiating basis on perusal of the ACRs, etc., etc. Next paragraph, my lord, the DPC therefore recommended regulation of officiating appointment of all the A's referred to above retrospectively. Now, Lord, kindly see in this order, these 11 persons who have been promoted, they have been given regularization with effect from in this table, my lord, with effect from 2007, 7, 7, 8, 8, 8, 8, 8, meaning thereby, and they have also cleared in the affidavit that these 11 posts were posts which fell vacant or available prior to 2008. And in the affidavit, they said after 2008, these 14 more posts have arisen. And for us, my lord, only 6 to 7 posts are necessary. Now, the Honorable Single Judge, I'll come to the finding, my lord. Honorable Single Judge has taken into consideration this part of the affidavit. Then, in my humble submission, subject to Lordship consideration, came to an abrupt finding that the government could not show.
Let us see.
Yes, my lord. Lordship will straightway turn to page 165, my lord, paragraph 28 onwards. Page 164, my lord.
It starts at page
164, my lord.
No, the
Judgment, my lord.
judgment starts.
Judgment starts from page 150. First page is 143 actually, with names, etc.
Hmm.
The judgment starts from page 150, 150. These 3 paragraphs will make the picture clear. Man.
Which paragraph?
Para 28 onwards, man. Page 164. Man.
Paragraph?
Para 28, my lord.
28.
28. May I read, my lord? The writ petitioners were promoted from the post of JE to AE on officiating basis on different dates and years. That is, petition number 1, so and so, all dates are given, my
Why
lord.
don't the council have a seat and interns also have a seat? There are seats vacant. Don't stand in the court. Sit to sit. If there are no vacancies, matter is different.
Yeah.
There are vacancies as per Mr. Mazumdar. So we should utilize the vacancies.
That is why, my lord. The whole problem.
Yes.
Yes, ma'am. The writ petitioners were promoted from the post of JE to AE on officiating basis on different dates and years. That is, petition number 1, 27/2/2008, petition number 2, 23/8/2 and 23/8/2009, petition number 4, 16/6/2010, and petition number 5, 6, and 7 on 7/7/2011. The promotion of the petition number 1 was purely on officiating basis against deputation vacancy arising out of deputation of 1 3 so and so, and the Department of Hydropower. The other petitions were promoted against quota meant for direct recruitment of the assistant engineer with clear terms that as and when direct recruits are selected by Public Service Commission, their appointment shall automatically stand terminated. On consideration of submission, Learned Standing Council, it appears that between the period 2001-2008 to 31-12-2012, which I have just now read, my lord, there were total 36 posts of assistant engineer available. Perusal of the minutes of the meeting of the DPC dated 24/7/2012, which I have just now shown, my lord, to your lordship, reflects that there were 8 backlog for direct recruitment quota due to conversion of 8 direct recruitment quota to promotional quota. Deducting 8 backlog posts for direct recruitment, total vacant posts were 28 posts. Arithmetically, as per relevant rules, 14 vacant posts each for direct recruitment quota and promotion quota were available between the period 2008 to 2012. As per DPC minus dated 24/7/2012 reveals that 8 posts of assistant engineer meant for direct recruitment quota were converted into promotional quota under one-time relaxation of 17/3/2008. Therefore, those posts were filled up by means of promotion to the seniors of the petitioners with retrospective effect, with effect from the date of officiating promotion, that is 21/3/2007 and 21/3/2008. In all, on the recommendation of DPC dated so, 11 junior engineers were promoted to the post of assistant engineer who were senior to the petitioner. It is also revealed from the record that by later dated so, a requisition was sent to the Public Service Commission for filling up 22 posts of assistant engineer by way of direct recruitment. On a clarification being sought, it was clarified that 20 posts were to be filled up by direct recruitment. There was a backlog of 17 posts that were to be filled up by direct recruitment, as there was excess promotion from the grade of junior engineer to assistant engineer, exceeding 50% posts meant for the promotional quota. The APC issued an advertisement on 23/11/2011, inviting application for filling up 20 posts of assistant engineer electrical under the Department of Power, Government of AP. Accordingly, consequent to the selection process, APS has selected the private respondents and recommended for appointment and were appointed to post of assistant engineer by order dated 18/7/2013. Therefore, the petitioners except petitioner number 1 who were promoted on officiating basis as assistant engineer against the quota meant for direct recruit stands terminated and discontinued on selection made by the Arunachal Pradesh Public Service Commission and consequent appointment of direct recruits. Perusal of the minors of DPC date 24/7/2012 clearly go to show that there were no promotional vacancies and the state.
This stands perhaps should have been stood.
Yes, man, stood.
Aren't you? This
Yes.
stands.
Yes, man.
I think stood.
Stood. Perusal of the minors of DPC dispenser clearly go to show that there were no promotional vacancies and the state respondents had accorded one-time relaxation of conversion of 8 posts of assistant engineer meant for direct recruit and had recommended the names of 8 junior engineers, namely so, for promotion to the post of AE, which were meant for direct recruit quota, and had further recommended the name of 3 others from promotion to the post of assistant engineer. Thus, there appears no vacancy for promotion of 8 junior engineers who were promoted after conversion of 8 posts of assistant engineer, which were meant for direct recruit quota. Needless to observe that on mere completion of length of time, now my lord, discussion goes further. This discussion did not continue thereafter as to actually whether those 14 posts reflected in the affidavit of the government were available for adjusting the petitioners. I'm reading, my lord, but this discussion is now different from 32 onwards. Needless to
Not required. These are not. This may not be relevant for the purpose.
my lord, that is
This
my,
adjudication
my,
process.
my.
Now, is there any finding that the affidavit of the government
My
the
lord,
stand taken
my lord.
was not matching with the records?
My lord, here I am showing it. Page 167, para 34, my lord. Let me read para 34 since my learned friend was also saying. Having observed the above position, page 167, my lord. On top, having observed the above position, it is difficult to fathom how the state respondents could submit that there were vacancies available. An attempt had been made to have review DPC to consider the grievance of the petitioner for promotion, regularization to the post of AE with a retrospective effect. However, could not be materialized on the flimsy excuse of not having been approved by the competent authority. If at all, there were clear vacancies and the authorities want to extend benefit to the petitioners, in my view, there would not be any absolute bar to consider the same, of course, strictly in accordance with law. However, except the stand of the state respondents in their affidavit, a record made available to this court does not support and fortify the said stand, rather is contrary to the same, as the minutes of DPC date so and so, where 11 junior engineers who were admittedly senior to the petitioner were promoted, reveals that 8 posts meant for direct recruitment were converted to promotional quota, coupled with the sending of requisition to APSC culminating into appointment of direct recruits, which makes it evidently clear that as on 24/7/2021, there were no posts available under the promotional quota for the petitioners to be recommended for the promotions. Admittedly, the petitioners were promoted on officiating basis in the year 2008 to 2011. That too either promoted on officiating basis against deputation vacancy or vacancy meant for direct recruits and were to be reverted back to their substantive posts of junior engineer once the same are filled up by direct recruitment. This is the affidavit, madam. Now, my lord, I am just.
But you say that your officiating arrangement was continued without any break later on by a subsequent
But
order.
two things are relevant here, my lords may kindly consider. And whether I am working against a DR quota or not, that is not the relevant factor. What is relevant is, since we have been officiating continuously from our initial officiating promotion, question is, we have a right to be considered for retrospective promotion, provided there are vacancies. The fact that we were continuing or working against direct recruit quota is, in terms of the order, is not relevant here for two reasons, my lord. Even assuming that we were working against direct recruit quota, lordship will kindly see just two documents at page 214, my lord. We have been working against a vacancy, not direct recruitment quota, prior to their induction through direct recruitment, my lord. Page 214, lordship will kindly see for a moment. Because, my lord, our initial appointment mentioned that we are appointed against direct recruit quota. Now, 214 is the letter dated 17/7/2013. By which, my lord, we were reverted to the post in order to accommodate the direct recruits. Consequent upon recommendation of Arunachal Pradesh Public Service Commission for appointment of 20 numbers of assistant engineer under Department of Power and in terms of terms and conditions given in the officiating appointment orders of assistant engineer electrical appointed against direct recruitment quota, the governor of Arunachal Pradesh is pleased to order reversion of the following junior engineers against direct recruitment quota to their substantive post as junior engineer with immediate effect of 17/7/2013. Lord will kindly take the note of the date on which we were reverted. Then next page, 2nd September 2013 is the order by which our position was again restored by reinstating us to the officiating promotion. Page 215, my lord, by letter order dated 2/9/2013. This is very relevant, my lord. The governor of Arunachal Pradesh is pleased to order officiating promotion of the following junior engineers electrical to the post of assistant engineer and other so and so in the pay scale of so and so from time to time in the interest of privacy with effect from 17/7/2013. Now, what becomes relevant is, my lord, we were again reinstated, although officiating from 17/7/2013, and the direct recruits were appointed on 18/7/2013, at least one day prior to them. And there is no challenge to our reinstatement from a date prior to their induction in the cadre. So we are senior to them by one day at least, or from a different angle, my lord, we were given officiating promotion against a vacancy, not against a DR quota, but against a vacancy the government has. They are saying we had a vacancy.
See, 214 is the reversion order.
My lord.
When were you given the officiating
Appointment, my lord.
appointment?
Appointment was in to page 82, Lord, you will find that order. One of the order.
24/7/2012,
2011, my lord.
2011,
My lord.
page?
Page 82 to 86, my lord. Page 82, my lord. This is 23rd August 2009 order. Different dates for different petitioners, my lord.
2009 to 2011.
My lord. Governor of Arunachal Pradesh is pleased to order officiating promotion of following
Which pay scale is this? The scale of AE or JE?
AE, my lord. AE.
Even scale was given.
Even scale was given, my lord. So, my lord, my submission is very, very short. What I am saying is, my lord, the last promotion that was made in 2012, which your lordship has seen at page 109, 11 persons were promoted and they were given retrospective promotion against vacancies which were available till the year 2008. Government affidavit makes it very clear that after 2008 till 2012, 36 more vacancies were available. Now, 8 posts to which the discussion takes place in the judgment were deducted from the total tally of 36. The 8 posts which were converted or taken away from the direct recruitment quota, they have been given by deducting 8 from 36. Now it comes to 28. From there, both the parties have to share in 50-50 equal ratio. And accordingly, 14 posts fall in our share. And so far as they are concerned, 14 plus 8, it becomes 22. And out of the 22, 20 direct recruitment were made in 2013, whereby the present respondents were.
How many vacancies were there initially?
Initially 36, my lord.
36.
My
8 were given, taken from the direct recruit quota.
And that has been deducted from the total tally because their vacancy position has to be
36 is the number of posts.
total post, my lord, vacancies.
Vacancies or posts?
Posts are where more vacancies were available, 30 vacancy, my lord. Cadre strength will be much more than that, my lord.
Okay.
And the government affidavit makes 2 things very clear. That total vacancy were 36 at page 187. And at page 186, they make it clear that this is a table showing 36 vacancies. And
So if you say
my lord,
that total vacancies were 36
my lord,
and those 8 numbers were taken from the direct recruitment quota.
earlier
backlog.
have been replenished by giving them again by deducting 8 from 36. The purpose of deducting 8 means to give it back to them. Earlier it was taken from them. So in order to fill up their quota, these 8 were deducted from the total tally. Now available vacancies become 28. After giving back their quota of 8 posts earlier taken away from their quota.
Okay. Yes.
And then, my lord, it says that 14 posts each were available to each of the groups. And so far as they are concerned, they will have 8 more, which was deducted from the total tally. So for them, it becomes 22. For filling up these 22, 20, some problem was there. So 20 direct recruitment took place, by which the present respondents were inducted on 18/7/2013 through the Public Service Commission, my lord, direct recruitment. Go by please, sir. So they have clearly shown, my lord, 14 more vacancies are available for accommodating the present appellant, who were the writ petitioners, with retrospective effect, my lord. That is my case, my lord. And this aspect of the matter has not been considered. From there, discussion takes place in a different perspective. The only thing that say that they don't have any right. Of course, in some cases, they can be considered, but
How do you deal with the observations made in paragraph 34? Mismatch with the records.
my lord, my submission will be so far as government record is concerned, my lord, it's for the government, my learned friend to point out. But the document itself, 2012 DPC, which I have shown, my lord, clearly shows that in the 2012, that is the last, my lord, promotion exercise was undertaken. After that, no exercise. So they are very clear, my lord, that they have in that DPC, the posts which were available prior to 2008 were taken into consideration. After 2008 till 2012, the government affidavit is clear. This is a statement of fact that from 2008 to 2012. So since we have regularly continuing against the vacancy, my lord, and against as of inefficient capacity and against the vacant post, in terms of the proposition 2, your lordship has seen that that recruit case, my lord. Even if the initial appointment was not made in accordance with rules, if they have continued without any interruption, then they can be given retrospective promotion. That is my submission, my lord. Judgment to say to citing to. And I'll give one more copy of the judgment before your lordship, my lord. Direct recruit case protocol for citation to. Nahi to na? That's my submission.
Okay, yes, permit.
And one aspect, since your lordship has taken up the whole writ petition for disposal, the IA that we filed, I am not pressing because in the IA we have annexed one document. Just have a look for a moment, my lord. Page 16 in the IA.
Which IA?
IA we have filed yesterday.
Is it 43?
It may be 43, my lord. This we had to file, my lord, because on 6th of February 2026, at page 16, my lord, of this IA, 16.
Yes.
This document has been issued inviting, my lord, the submission of SCR, etc., for the purpose of undertaking an exercise for making promotion to the post of EE from the gradation list which was prepared during the pendency of the writ petition. My lord, they have themselves have mentioned that the preparation of final gradation list is subject to the outcome of this writ petition. Now, if they undertake this exercise that they will fill up the post, my lord, the petitioner will be prejudiced. Paragraph 2 step 2
From A to executive engineer.
my lord.
Here there is no post of assistant executive engineer. Unlike Assam.
Assistant engineer.
No, assistant executive engineer.
No,
there is
I think no.
Assistant engineer to-
In Assam, it is there.
From assistant engineer to executive engineer.
Yes. By this document, the Undersecretary has written to the Chief Engineer, I am directed to inform you that DPC for promotion from AE to EE is going to be held very soon to fill up few vacant posts of executive engineer in the department. Therefore, it is requested to kindly furnish the ACR for last 5 years vigilance clearance certificates and annual property returns filed up to 31/2025 and integrity certificate as mentioned in the following respects by 19th of February 2026. This date is important, my lord. And one more document I would like to show, my lord. The page 48. This is based on the this list they have prepared because those who come within the zone of consideration according to the final central list they have prepared. The final central list is prepared by memorandum dated 29/1/2026 at page 48, man.
What is 48?
Page 48 of this IA, my lord. This final gradation list prepared on 29/1/2026.
Intersessionality list.
My lord. But that was subject to the final outcome of even this writ appeal. That is what I want to show, man. So in the middle, my lord, they have mentioned on the recommendation of the screening committee, the final inter-se seniority list of estimating engineer under Department of Power has been prepared and enclosed as Annexure A. However, the seniority list of AE shall be subject to review and modification based on
We
the
have read that.
final outcome. So since your lordship is taking up the whole matter, we are not required possibly to. Otherwise, my lord, they will go ahead with the promotion. My lord. So this judgment, my lord, your lordship is aware that director group is proposition number B of para 47. I'm relying.
Of Director Two.
Yes, my lord. Director group 2, 1990, volume 2 SCC, page 715. 1990, volume 2 SCC, page 715. 47B. Para 47B, proposition B, my lord.
Okay.
That's all.
Yes, say, department.
May I sign, my lord? Our epidemic, my lord, will find at page number 173, my lord. Start from 173, my lord.
What is that? 173?
Our epidemic, my lord. Epidemic opposition, my lord. Relevant, I will start from 175, my lord.
At 175.
5, my lord.
Yes.
Para 4, my lord, we have explained how the vacancy position, my lord. Now, before this actually vacancy after 2008, my lord. Now, we have enclosed one document that is of DPC 2005, my lord. To show that, my lord, up to DPC 2008, my lord, the 50-50 ratio, my lord, was well maintained, my lord. At the 2005, my lord, there was an excess appointment of direct recruitment quota, my lord, for the in promotion, my lord. Accordingly, that was again equal, my lord, in DPC 29/12/25.
What are you reading?
That documents we have annexed at page number 198, my lord, 198, my lord. This only to show that, my lord, up to 2005, my lord, by DPC 2005, my lord, 50-50 ratio, my lord, by the for the promotion in direct, my lord, was maintained, my lord.
Till 2000?
5, my lord. At 3, my lord.
Till 2005. 50-50 ratio was maintained.
Million. Just to show that we have annexed this document, my lord. My lord will kindly look into para 3, my lord. It was informed by the department that the 16 vacancy of assistant engineer against promotional quota was available at present, which include six backlog vacancy brought forward against excess direct recruitment quota in the past to strike the balance in ratio for promotion and direct recruitment as per RR, my lord. Now, thereafter, my lord, DPC, my lord, have seen it to 12, my lord. Now,
After 2005. After 2005, next DPC 2012.
12, my lord. Now, my lord will kindly note one thing, my lord. 2012 DPC, my lord, was not for the vacancy arise between 2008 to 2012, my lord. It was a DPC to regularize the direct in 2006 promoting, my lord, who is where given officiating promotion by converting 8 posts of direct recruitment, my lord. They have given officiating promotion in a post by converting 8 posts of direct recruitment quota, my lord. Now that conversion, my lord, was in 17/3/2008, my lord. Now, even though DPC, just I want to point out that though even the DPC was in 2012, my lord, that was post prior to 17/3/8, my lord, not after that, my lord. As the conversion, my lord, was in 17/3/2008, my lord. If
How many were converted?
8, my lord.
So are you contending that the DPC held in 2012
Yes, my lord.
was only for the purpose of regularizing the services of those 8 numbers of promotees
Promoted.
who were given officiating promotion in the year 2008?
8, my lord. Because, my lord, also to say that, my lord, the post after, my lord, 17/3/2008, my lord, was not in consideration before the DPC 2012, my lord.
Post before, post after?
After 17/3, my lord, 17/3, my lord, 2008, my lord.
Were not the subject matter of consideration?
My lord, because, my lord, this, my lord, see on the record is saying, my lord, conversion was on application, my lord, it was convert on 17/3/2008, my lord. Now, thereafter, my lord, will kindly see, my lord, from page 177, my lord, we have tried to.
Where did you get this? You just read 17/3/2008 from the
That is DPC, my lord, of the minor of the DPC.
198, page 198, which part?
One, DPC 2.5, my lord.
Yes, that is at page 198.
198, my lord.
Yes. Where is this part?
The following were present, my lord. Thereafter 3, my lord. It 3, my lord. Serial number 3, my lord. Second is DPC examiner position of seniority list, my lord. Thereafter, my lord. It was informed by the department that 16 vacancy, my lord. (198), my lord. I have type out also. Type out, my lord. Will find at page number 200, my lord.
Yeah, we can read this. There's no difficulty in 198.
My lord. 198, my lord. After 2, my lord.
Yes, we've read this. It was informed by the department that 16 vacancies of Eastern engineers, electrical against promotional quota are available
My lord.
at present, which includes 6 backlog vacancies brought forward against excess direct recruitment in the past to strike a balance in the ratio of promotion. Okay.
My lord. I'm indicating this document, my lord, in that ultimately by 2 times DPC, my lord, the 50/50 ratio, my lord, was maintained, my lord, promotee and direct, my lord. Fine. Now, my lord has seen that DPC 2 times 12, my lord.
Page
204, my lord. Oh, sorry, my lord, that is type out, my lord. Annex number B, start from 202, my lord. Type out, my lord, will find it 204, my lord.
Yes, what is this?
This is the DPC 2 times 12, my lord. Second para, my lord.
Mr. Mazumdar's clients were promoted by this.
No, my lord. This was, my lord, the DPC, the person, my lord, who were given officiating promotion in a direct recruitment quota, my
We
lord.
were promoted in 2022, but prospective.
Prospective.
Now, this is for whom? To 2012?
2012, my lord. In 2008, my lord, there were the 8 posts of direct recruitment, my lord, were converted into promotional post, my lord. Promotional post, my lord, and giving officiating promotion, my lord. To regularize those promotion, my lord, this was given, my lord. Required. If my lord, can you read the minute, my lord? 204, my lord, para 2, my lord. The DPC was informed that in the year 2008, based on the representation submitted by the APSI graduate engineer, the state government has accorded one-time relaxation for conversion of 8 posts of AE mean for direct recruitment quota to promotional quota by order such and such dated 17/3/2008, my lord. Now, my lord will kindly note this date, my lord, 17/3/2008, my lord. This is relevant in this case, my lord. 17, the conversion, my lord, was 17/3/2003, my lord. So this DPC was up to the post before 17/3, my lord, not after 17/3/2008, my lord. Accordingly, the department had considered officiating promotion of 8 AE, namely such and such. To that, department has also given officiating of 3 such and such, namely such and such. Now, by this DPC, my lord, those posts is regularized, my lord. Now, my lord, again, after that, my lord, after 3, we have at page 173, my lord, we have tried to specify how the vacant posts start from 31/3/2008 to 2012, my lord. That we have specified, page 177, my lord. Now, with page numbers 78, my lord, in column, in table, my lord, we have tried to specify, my lord, how the post become vacant, my lord. One, my lord, we'll see 2008, my lord, 1 post became vacant, my lord, because, my lord, so once Arun Kumar Singh was promoted EE bid order dated 28/12/2008, my lord. Now, due to his promotion, my lord, 1A post of A become vacant, my lord. Similarly, in 2009, my lord, this one Guy Taki was promoted bid order dated 2/3/2009, my lord. Similarly, my lord, we have tried to work out and how, my lord, that up to 36 posts, my lord, starting from 31/3/2008 to 31/3/2008, my lord. 36 posts were vacant, my lord. Were vacant, my lord. Now, therefore, my lord, even if in 2012, my lord, DPC, my lord, suppose this the post mean for the direct recruitment, my lord, 8 post, my lord, for direct recruitment is taken out from this statistic, my lord. Between 2008 and 12, my lord, there will be a 28 posts, my lord. 28 posts by me as per RR, my lord, this should be 14 to vote, my lord. The dark contestant.
50%.
50%. Taking out the those 8, my lord, which is convert by the order dated 2008, my 8, my lord. This is 17/3/2008, my lord. And we have in table, my lord, we have tried to specify by what date, my lord, how, my lord, this post become vacant, my lord. So my humble submission, my lord, maybe, my lord, subject to consider or my comment. Lane Singh has misconstruct that this as DPC was held in 2012, my lord, and there was a mention of conversion of direct recruitment, my lord, quota of direct recruitment for promotion, my lord. That's why he said, my lord, this is not part of the record. But in the table, my lord, see, we have tried to specify the record also, my lord, how this post become vacant, my lord. But 2012, my lord, it kind of that was not the post for DPC for the post between 2008 to 2012, my lord. This was simply, my lord, before that, my lord, conversion 17 to 2008, my lord. That the limit submission, my lord.
Okay. Here for
Respondents numbers in this appeal.
Before my lord, my friend, my lord, make submission, my lord, as a appellant, my lord, may I complete my submission, my lord. Item number
Is there
4.
anything to add to Mr. Mazumdar?
Yes.
You have anything to add?
A little different, my lord, in factual aspect, my lord.
But do not repeat what Mr.
Yeah,
Mazumdar.
my lord, my lord.
Mr. Payne, then let him, you can give a common reply then.
Yes.
We thought that your part is covered by Mazumdar. Before the standing council, we could have
Yes.
heard you. Okay, doesn't matter.
My lord. Well, basically, my lord, the appellant herein was also, my lord, a writ petitioner in the writ petition, my lord. Writ petitioner number 1, my lord. I have segregated myself and filed a writ appeal, my lord. The factual difference is that, my lord, the petitioner was initially appointed as a, my lord, junior engineer. My lord, I have got the list of dates. There's so few dates, my lord, only.
But there were two petitions which were disposed of.
Yes. One writ petition is by my friend, my lord.
Yours will be covered by the submission. Or you have not
Yes.
filed any appeal.
He has filed the appeal.
There is an appeal. There are 3 appeals before us.
See,
3 appeals.
Yes.
We said 28 and 35. What is yours?
01.
Hmm?
1 of 2025. With April 1 of 2025.
Against judgment?
Judgment and order that page.
1912, which has followed 31/8/2024. Your judgment has followed the earlier judgment of 31/8/2024, correct?
Yes.
May I please, my lord?
Yes.
Well, here the appellant was initially appointed as a junior engineer on 15/10/1994, my lord. 7/10/1994, my lord.
Hmm?
Initially appointed as a junior engineer on my lord 1994, my lord.
Yes.
My lord, 3 my lord assistant engineers of the my lord electrical department, power department was sent on deputation to the hydropower department, my lord. Against one of the my lord deputation vacancy, my lord, I was my lord promoted on officiating basis as a assistant engineer, my lord, on 27/2/2009, my lord. And while what I want to impress upon your lordship is that, my lord, I was appointed on officiating basis against a deputation vacancy, my lord. And my lord, Ultimately, my lord, I was given, my lord, all the pay benefits by order dated 2/2/2009, my lord. My lord, kindly for a moment, my lord,
You
that
are
order-
given pay scale.
pay scale, my lord. And my lord, in that order, my lord, there is a mention that, my lord, on return of the deputation, my lord, I may be reverted back to my original post,
Yes.
my lord, of junior engineer, my lord. However, my lord, the deputationists, my lord, were permanently absorbed in the hydropower department on 16/5/2012, my lord.
Yes.
With effect from, my lord, 27/2/2009, my lord, retrospectively, my lord. Which you'll find at page 59, my lord,
Of?
of the, my lord, my
Of your-
appeal, my lord, yes,
your
my lord,
appeal.
page 58, my lord. Despite, my lord, the deputationists were being absorbed in the
Just a minute, please. 58.
58, my lord. Page 58.
What is this? 58, 24, 6, 20.
24/6, my lord, whereby, my lord, scales were given to us, my lord. I am at serial number 3, my lord. Promoted against the deputation of Sri Gumto Ete, my lord. And the promotion is purely on officiating basis against the deputation vacancy. Will not bestow on them any claim for regular appointment as assistant engineer, and officiating service or rendered would not count for seniority confirmation, etc., and will be governed by outcome of 432 of 2008, my lord. My lord, this writ petition was, my lord, I was in the meantime, I was reverted, my lord, back to, my lord, junior engineer. I filed a, my lord, writ petition challenging the reversion that it was, my lord, wrongly, my lord, reverted me, my lord, because I was given officiating promotion on deputation vacancy, my lord. And, my lord, the persons who were on deputation were absorbed by an order dated, my lord, next page, my lord, 59, 16/5/2012, my lord. Mayor, my lord, the governor of Arunachal Pradesh is pleased to order to absorb permanently following assistant engineer of Department of Power in the post of EM with effect from date of their initial appointment on deputation as given against each in the pay band of such and such, such and such. I am, my lord, these are the persons, my lord, serial number 1, 2, and 3, my lord. Against 3, my lord, I was, my lord, initially given officiating promotion, my lord. Gumto Ete, my lord. And till then, my lord, we have been continuing in the same post of assistant engineer. And DPC was not held, my lord, for regulation of our post, my lord. In 2012, a DPC was held, my lord, on, my lord, 24/7/2012, my lord. My lord has seen the order, my lord. Again, my lord, for the sake of repetition, my lord, kindly, my lord, peruse the DPC of 2012, my lord, at page, my lord, 161, my lord. This DPC was basically held, my lord, for regulation of those officiating, my lord, promotees, my lord, who were promoted on officiating basis against the direct recruitment quota, and by one-time relaxation, my lord, they have been, my lord, given officiating appointment at that on 2008, my lord. and were regularized in the year, my lord, by a DPC dated 24/7/2012, my lord. May I read this, my lord? The DPC, my lord. This is only for the purpose of regularizing, my lord, those 8 persons, my lord. 11 persons, my lord.
8 persons.
8 persons, my lord. 8 persons, my lord. And third paragraph, my lord. On the perusal of ACR, it is seen that ACR in respect of Tajong Mesar for the period of 1/4/2003 to 16/6/2000 are not available. Only his ACR for the period from such and such is available. However, my lord, the officer has expired in the month of September 2011, my lord. One, my lord, whose consideration was taken, my lord, in the DPC as serial number 4, my lord. He expired, my lord, before the, my lord, DPC was convened, my lord. In the third paragraph, my lord, however, the officer had expired in the month of September 2011, the minimum, my lord. And my lord, he was also considered by the DPC held on, my lord, 24/7/2012, my lord. So, my lord, to my respectful submission is that out of 8, my lord, the persons, my lord, only 7 persons were, my lord, regularized, my lord. Practically, my lord. One has already expired, my lord, before the DPC, my lord. Meaning thereby, my lord, out of 8, practically only 7 persons were regularized, my lord, against the direct recruitment quota, my lord, which was exhausted later on, my lord. And pursuant to that DPC, my lord, regularization order was passed at page 161, my lord.
Yes.
In the regulation order also, my lord, his name was reflected, my lord. The deceased person's name was reflected, my lord. And my lord, thereafter we filed representation, my lord, for consideration for our regulation, my lord. My lord, no, my lord, DPC was convened, my lord, which is in total violation of the NR Banerjee's case, my lord. My lord, in order to fill up, my lord, the direct recruitment quota, my lord, there's some posts were, my lord, sent to my lord, APCS, my lord, for my lord, by and my lord, the APCS recommended, my lord, by an order dated 17/7/2013, my lord, at page, my lord, 235, my lord. All right. All right, in order to pave way.
Just a minute.
Okay.
Yes.
My lord, the Public Service Commission, my lord, has recommended altogether, my lord, at page 312, my lord.
What is 235?
I'll come to that, my lord, later on, my lord. In order to, my lord, accommodate these persons, direct recruitees, my lord, page 235, the office sitting, my lord, 18 office sitting, my lord, assistant engineers were reverted back, my lord, to the post of junior engineer. However, after the appointment of the, my lord, direct recruitees, again an order was passed at page, my lord, 236, my lord. Whereby, my lord, altogether again, 12 persons, my lord, officiating assistant engineers who were reverted back by an order dated 17/7/2013 were reinstated, my lord, with effect from 17/7/2013, my lord. In that reversion order, my lord, in order to fill up the direct recruitees, my lord, my name does not appear, my lord. I was never reverted back, my lord. The present appellant, my lord. The rest, my lord, rest were, my lord, reverted back, my lord.
Your name does not appear in 17/7/13.
Yes, my lord. The rest appellants, my lord, in other writ appeal, they were, my lord, reverted back, my lord. Again, my lord, by an order dated 2/9/2013, those persons who were reverted back to the post of junior engineers were again given officiating promotion with effect from 17/7/2013, my lord.
Yes.
And my lord, what, my lord, the direct recruiters contention is that, my lord. Once the, my lord, 20 posts were, my lord, filled up, my lord, and the observation of the learner single judge is also, my lord, there is no, my lord, vacancy for the promotional quotas, my lord. In fact, my lord, kindly take the page 312, my lord. They are saying that, my lord, 20 posts of direct recruitment has been filled up, my lord. But, my lord, out of 20 posts, my lord, we are concerned with only, my lord, the electrical branch, my lord. Now, electrical branch, my lord, only 13 posts were filled up, my lord, not, my lord, 20 posts, my lord. Serial number, my lord, 1 to 10, 12, 13, serial number, I am giving the serial numbers, my lord. Serial number 1 to 10 are electricals, my lord. And, my lord, 11 is mechanical, 12 is electrical, 13 is electrical, 14 is electrical, 15 is mechanical, 16 is computer science, 17 mechanical, 18 mechanical, 19 mechanical.
Five are others. 15
Yes.
are also filled up.
Yes, my lord.
15 belong to electrical, isn't it?
Yes.
No more. 1,
13, my lord.
2, 3, 4, 5, 7. 7 belongs to other department.
Yes, my lord. 13, my lord, electricals, my lord. So the findings of the learned single judge is also incorrect, my lord, because my 20 posts of electrical engineers were not filled up, my lord. Only 13 posts, my lord. Rest are, my lord, mechanical and computer engineers, my lord. They have different trade, my lord. And then in the judgment, my lord, it was also admitted that, my lord, that I was, my lord, given officiating promotion against the deputation vacancy, my lord. These aspects has not been, my lord, considered at all, my lord. While saying that, my lord, there were no vacancies, my lord. And the affidavit has already filed by the State Department, my lord, showing the vacancy position, my lord. This is my limited submission, my lord. Now-
Mr. Saikia, if you go strictly, a vacancy caused by a deputation is not a vacancy in the eyes of law.
My lord.
it is a contingent vacancy. The deputation may come back at any moment.
my lord.
It's a different matter that this deputation is
Were
got absorbed
Yes, my lord.
in the department.
My lord.
So vacancy arose.
My lord.
So
And only to show that, my lord, continuous officiating promotion till,
that you can argue that you are continuously officiating. So you fulfill proposition B of
that
direct
duty
recruit
case,
two
my lord.
case.
Yes, my lord.
Okay.
Obligation.
Yes, Mr. Yes, Mr. Lampu would like to argue? Or is it covered?
In my case, my lord, they are not respondent, my lord. There is no private respondent, my lord.
Yours is WA?
01/2025, my lord.
WA 01 of 25.
Yes, ma'am.
We are not part.
We are not parties, my lord.
No further.
One petitioner, one appellant.
Yes, ma'am, one appellant only. In fact, I am the senior most JA, my lord. And they have not disputed that.
Into recruitment rule kadune adda kangada.
I have only one factual aspect.
That is only difference. Anything else?
No, my lord, I have not submitted it.
No, let us see.
Yes, my lord.
Yes.
Yes.
Firstly, my lord,
Okay.
may I take your lordship to page 119 C, my lord.
Martaba.
This is the impugned DPC, my lord.
Pagundal Gaman.
119.
119 miles.
That is the provisional seniority list.
No, my lord. 1119 C, my lord. Within bracket C, my lord. One one nine within bracket C. This is the DPC, my lord. This is which was
27 May.
yes, my lord. 27 May 2022, my lord. My lord, this is regarding my lord regularization of my promotion only, my lord. And my lord, I like to show from this documents, my lord, what has been considered and my lord, what was the outcome, my lord. And firstly, my lord, may I read this?
Yes.
My lord, in pursuance of the Honorable Guwahati High Court order dated such and such in WBC number such and such, wherein it was directed that the respondent authority consider the promotion of Sri Nani Pasang to the
You are the appellant, Nani Pasung.
yes, Nani Pasang.
Electrical,
My lord,
electronics application dostana.
in this impugned DPC, my lord, consideration is regarding my lord regularization of my officiating promotion to the post of assistant engineer. Thereafter, my promotion to the post of executive engineer, my lord. My lord, but my lord, what was the outcome, my lord? That is at paragraph 3, my lord. Paragraph 3, my lord. Paragraph 3, my lord. After taking into consideration the grading recorded in such and such, prescribed benchmark and such and such, all available document, the DPC found him fit for promotion and recommended for promotion of Sri Nani Pasang to the post of AE with effect from date of DPC. Hello, consideration is regarding regularization of my officiating promotion to the post of assistant engineer. Thereafter, my lord, after regularizing my post to the post assistant engineer, my promotion for the post of executive engineer has to be considered, my lord. But what they did, my lord.
No, from where do you get the agenda? That there is another part of the DPC to consider your
Yes, my lord.
further promotion to the post of executive engineer. Where do you get the agenda? What is the agenda?
My lord, that's so my lord, paragraph
The
1,
agenda is only for regularization of your officiating promotion.
my lord.
The agenda is only for regularization of your officiating promotion.
Yes,
Please read the first headline of the DPC.
Yes, my lord.
Minutes of the DPC to consider regulation of officiating promotion of three students.
My lord.
That is the only agenda. There is no further agenda of your promotion to the post of executive engineer.
No, my lord, down below, my lord. Kindly see, my lord.
Yes, where?
A meeting of DPC to consider regularization of officiating promotion of Sri Nari Pasang AE and promotion to the post of executive engineer electrical under the Department of Power held on 27/5/2022.
Where are you reading?
My lord, the paragraph
Oh, okay.
down below, my lord.
A meeting of DPC
First paragraph. First paragraph.
was held on 27th September. Yes.
Yes, my lord. But consideration that what they did, my lord, my regularization was, my lord, considered from the date of DPC, my lord. And this, my consideration for promotion to the post of executive engineer was, my lord, withheld, my lord. Since, my lord, as per recruitment rule, my lord, 10 years is required. 10 years of regular service is required in the post of assistant engineer to be promoted to the post of executive engineer. My lord, why I am, my lord, showing these documents to your lordship is that, my lord. Well, initially, my lord, I was appointed, my lord, as a junior engineer on 21 January 1994, my lord. 21 January 1994, as page 52, my lord, at page 52.
Appointed as junior engineer.
Junior engineer on regular basis, my lord. My lord, my appointment will find at page 52, my lord. Page 52 is my appointment order. Thereafter, my lord, as per the recruitment rule, my lord, I'm a diploma holder. My lord. For diploma holder,
8
Oh.
years.
at that time 10 years, my lord. Now it's 8 years. My lord. There is no dispute on that. My lord. Thereafter, my lord, what happened, my lord? As per the recruitment rule, I was eligible to be promoted, my lord, to the post of assistant engineer in the year 2004, my lord. And my lord, since my lord, 2000, since from 2004, my lord, though I am eligible, my lord, my case was not considered, my lord. However, my lord, on 27 February 2008, my lord. On 27 February 2008, I was given officiating promotion against the direct recruitment quota. My lord.
Yes.
So thereafter, this appointment, this officiating appointment has been withdrawn, my lord, by an order dated 12 May 2009. my lord.
12.
12 May 05, 2009.
Which page?
Page, my lord, 104. Page 104. Thereafter, my lord, this withdrawal order has been challenged by the petition appellant before this honorable court, my lord. And by the order of this honorable court, my lord, he was reinstated on 24 June 2009. At page 105, my lord. Against the deputation vacancy. And that is at page, my lord, 108. my lord.
Now you said 105.
105 is reinstated, my lord. My lord, I'm sorry, my lord. 105 is my lord, my reinstatement. And 108 is my lord, that deputation they have been absorbed to the department of DPD, that is borrowing department. my lord. Now, my lord, what happened, my lord, thereafter, my lord? My lord, in the year 2012, my lord, there was one DPC, my lord, that is already sworn. My lord, in that DPC, my lord, one Janu Tang and Funyo Gabbo, who are junior to the petitioner, my lord, appellant, present appellant, there has been, my lord, promoted to the post of assistant engineer with retrospective effect from that of their officiating promotion. Well, that has been challenged by the petitioner in writ petition number, my lord,
The two juniors, their services were regularized
regularized.
retrospectively.
Yes, my lord. That has been challenged, my lord. My lord, that writ petition, my lord, the writ petition is, my lord, writ petition 11 of 2013, my lord.
You filed.
Yes, I challenged their appointment because they are junior to me in the cadre of junior engineer.
Yes.
My lord, thereafter, my lord, this honorable court, my lord, under single judge, by order dated 24 September 2013, my lord, dismiss the challenge of petitioner.
11 of 13 was dismissed.
Yes, my lord, 11 2013 dismissed on the ground that, my lord, by order on the ground that, my lord, since, my lord, Janu Tang and Nyogambo, although they are, my lord, junior to the petitioner in the cadre of junior engineer, my lord, since they are degree holder, therefore they have still a march over the petitioner. My lord. That is the reason only. But, my lord, in that order, my lord, that judgment, my lord, I take your lordship to that judgment. Relevant para, I'll take straight to relevant para. 114, my lord. Page 114. Paragraph 13, my lord. 114, paragraph 13. May I read, my lord? The learned counsel of petition has also referred to the certain decisions reported in such and such and such and such. These two decisions have been reversed, so is to argue that the said two incumbent could not have provided with prospective promotion without considering the case of petitioner. The ratio laid down in the said two cases is of no help to the cases of petitioner. Although he was appointed along with the posted two incumbents in the case of junior engineer, but because of provision in the rule 1993, the said two incumbent could not score a march over the petitioner, which cannot be false to do it. In view of no direction can be issued for inclusion of name of petitioner in the individual gradation list. However, it is here provided that depending upon the eligibility and zone of consideration, his case shall be considered for promotion to the post of assistant engineer from the due date. Now, thereafter, what happened, my lord? Since 2012, my lord, there is no DPC, my lord. Till, my lord, 27th May 2022, my lord, there is no DPC at all. But, my lord, the appellant herein, my lord, has pursued the matter to the concerned authority, my lord, regularly. Ultimately, by an order dated, my lord, 11/11/2021, my lord, which is is in page 118, my lord. Next page, my lord.
118.
Yes, my lord, 118, my lord. My seniority position has been recalled, my lord. My lord, by this order, 11 November 2021, my seniority position has been recalled. Since, my lord,
Yes.
since, my lord, it is conscious upon the respondent, my lord, I'm the senior most junior engineer at that point of time. But because of, my lord, non-holding of DPC, my lord, for last decade, more than a decade, my lord, my promotion was not considered, my lord. Thereafter, what happened, my lord? A provisional seniority. One more thing, my lord. This, my lord, page 118, my lord. recording my seniority, my lord, is not, my lord, challenged by any of the, my lord. Whether it may be, my lord, promote or direct equity, my lord. Because they knows, my lord, I'm the senior most, my lord. Ultimately, but thereafter, what is, my lord, a provisional seniority, that is next page 119, my lord. Provisional seniority list has been published, my lord. And I was placed at serial number 2 in seniority list, my lord, provisional seniority list, age 1, 12, 11, 2021.
You're Nani Pusam.
Yes, I'm 02, my lord. And this was not, my lord, disputed by any of the, my lord, serving assistant engineers, my lord, whether they may be direct equity or, my lord, promoted. Thereafter, my lord, what happened, my lord? Thereafter, my lord, this impugned DPC was held, my lord, for consideration of my regularization of my lord, opposite promotion as assistant engineer, and thereafter to consider my promotion to the post of junior engineer. But what I like to submit, my
Not junior engineer.
sorry, my lord, executive. I'm sorry, executive. No, my submission is that, my lord, in all aspects, as per the rule, my lord, petitioner was eligible for promotion to the post of assistant engineer way back in 2004, my lord. And, my lord, thereafter official promotion has given to him, my lord, in 2009, my lord. And he was holding that post till 2022, my lord, continuously without any package, my lord, in same scale of pay, my lord. But it is because of the non-holding of DPC, my lord, in time, my lord, my right to be promoted to the post was curtailed, my lord. And one thing, my lord, which I like to point out before your lordship, my lord, can I take your lordship to page 108, my lord? 108.
So how's your case connected with the judgment rendered in Mr. Mazumdar's case?
My lord, in my, I have relied, my lord, Moli Tatu case, my lord.
No.
Yes,
The
my,
judgment,
Yes, my lord.
these writ appeals have been listed for analogous consideration.
Yes,
There are two judgments.
my lord.
The judgment which has been rendered in the other two appeals,
Yes, my lord.
how is it connected?
My lord, kindly see, my lord, this impugned judgment, my lord. 224,
Page?
page 224. 224. Paragraph 23, my lord. Page 224, I will also quote, my lord.
Yes.
Paragraph 23. At this stage, my lord,
Yes.
at this stage, the decision relied upon by the learned counsel for the petitioner in the case of Moli Tatu Supra is required to be considered. It is to be noted that the said decision was considered by the coordinate bench of this court in the case of Marto Kamgo Supra. Well, they are appellant in item number 3, or my 4, I'm sorry, and had concluded that said decision is distinguishable basing on the fact as available in the said case. This court is in respectful agreement with the conclusion so reached in the matter by the coordinate of this court in the case of Marto Kamgo, and accordingly hold that the reliance placed by the learned counsel for the petitioner in the decision of this court in Mol Tatu Supra would not advance the case of petitioner herein. My lord, I have relied Moli Tatu case, my lord. In that Moli Tatu case, my lord, this preposition law of law has been considered, my lord. if, my lord, this officiating is continuously without any interruption, and there is vacant post, my lord, then, my lord, this retrospective promotion can be considered, my lord. In line of, my lord, this direct recruitment case, my lord. In the line of the direct recruitment case, my lord. In Maulik Tatu case, this has been relied on. But, my lord, what the learned single judge has decided, my lord, since, my lord, this Marto Kango case, since this, my lord, since Maulik Tatu case has been, my lord, distinguished by the coordinate bench, the coordinate bench in Marto Kango case, therefore, my case will not be, my lord, acceded to, my lord. Will not, it will this, my lord, it cannot be, my lord, give any help to me, my lord. Although, my lord, fact is same, my lord, in the case of Maulik Tatu and present applicant. And, my lord, by order of this honorable court, my lord, it has been taken with item number 4 and 5, my lord. Otherwise, my lord, in my case, my lord, it is clear, my lord, there is vacancy. I'm
What is
eligible,
Maulik Tatu?
my lord.
What is Maulik Tatu?
Maulik Tatu. Lord, I'll come to the 11th paragraph, my lord. Paragraph 45, my lord. It page 37. My lord, this is paragraph 45. My lord. Paragraph 45, my lord. May I read now? After careful consideration of the above observation and principle of law initiated by the Honorable Supreme Court and this court could not have any disagreement with the same as the observation on the facts and circumstances of the particular contextual facts. There would not be any quarrel with the principle of law as initiated above by the Honorable Supreme Court. This court is of view that the case referred to above by the Honorable Council have no automatic or universal application in the facts of the present case, as all the decisions and propositions of law have been rendered on the attending facts and circumstances of each of these cases, except the case of Myum Karga, and the same appears to be relevant on facts and law. So this court is also of the view that there is no absolute bar for granting promotion, regularization, with retrospective effect under the law, and it would depend on the attending fact and circumstances of the particular case. The next paragraph, my lord, there are 46. This court is not obvious of the settled principle
Oblivious.
of law. Oblivious. I'm sorry. This court is not oblivious of the settled principle of law by the Honorable Supreme Court in a series of decisions, including the above cases relied on by the parties that a promotion takes effect from the date of being granted and not from the date of occurrence of vacancy or present. However, with utmost respect, this court is of view that there would be not a complete bar for consideration of promotion or oblique regularization from date of ad hoc promotion, particularly where the incumbent is promoted on ad hoc basis on clear vacancy and allowed to continue without break, with all benefits of that post being eligible in all aspects due to delay in conduct of DPC for a long period of 14 years or so. Their delay on the part of the DPC in convening this meeting should not be resulted in a prejudice to the PTC, who were eligible for promotion or to have promoted but were not considered with respect to year in which the vacancy arose. And this is, I have liked this Molita to face, people will learn single judgment. And one more, my lord, case, my lord. Case, my lord.
This in Molitato, NR Banerjee was relied upon, NR Banerjee.
My lord.
In the case of judgment of Molitato,
Yes, my lord.
was there a reliance reference to NR Banerjee case?
No, reference is with this direct recruitment case was
No,
there.
no, what are the cases relied upon?
Yes, my lord. Direct recruitment. My lord, this direct recruitment class 2 engineering officer association versus system of Madhya Pradesh was relied.
Maharashtra.
Maharashtra, sorry. Maharashtra was relied, my lord. On the line, on same line it's what. And my lord, the one more, my submission. In the interim order now is the phase judgment of the last single hearing. I have also relied on judgment of Honorable Supreme Court in PN Premachandran. My lord, that has been, my lord, discarded by the landed single judgment. Is not. My lord, it's very small, but it will cover my case now. My lord, paragraph 7, page 2. Paragraph 7, my lord. Page 2. Read. It is not disputed that the posts were to be filled by promotion. We fail to understand how the appellant, keeping in view the facts and circumstances of this case, could question the retrospective promotion granted to the private respondent herein. It is not disputed that in view of the administrative lapses, the Departmental Promotion Committee did not hold a sitting from 1964 to 1980. The respondent cannot suffer owing to such administrative lapses on the part of State Kerala for no fault on their part. It is also not disputed that in ordinary course they were entitled to be promoted to the post of assistant director in the event a departmental promotion committee had been constituted in due time. In that view of the matter, it must be held that the state of Kerala took a concise decision to the effect that those who have been acting in a highest post for a long time, although on a temporary basis, but were qualified at the time when they were so promoted and found to be eligible by the departmental promotion committee at a later date, should have promoted with retrospective effect.
Yes.
My lord, in nutshell, my lord, since my lord, the appellant was eligible in all aspects, my lord, and there is clear vacancy, my lord, and that vacancy is promotional quota, my lord, mean for promotional quota, my lord. That is not disputed by the state respondent, my lord. And it is because of delay in convening the departmental promotion committee, my lord. In time, my lord, my promotion was not given, although it was due on 2004, my lord.
You are seeking a promotion from which date?
My lord, I'm seeking for 2009, my lord. But my lord, if we, my lord, in particular, my lord, if say, my lord, from date of their absorption to the to the parent department, the borrowing department, the depositors they have been absorbed into year 2012 in the borrowing department, my lord, permanently, my lord. If not 2009, my lord, from 2012, my lord. Thank you.
Yes.
My lord, may I take your seat to my absorption, their absorption order, my lord. Page 108, my lord. Page 108. I think, well, they have retrospectively absorbed, my lord, from 2009, from date of their, my lord, deputation. Page 108, my lord. This is type copy, my lord. So I'm, my lord, appointed against serial number 2.
What is the date?
That is 27 to 2009. Date of deputation.
No. This
Yes, ma'am.
108.
108, my lord. My lord, 16/5, 16/5. 16/5, 2012, my lord. No, 107 is the original copy, my lord. 108 is typed copy, my lord.
Yeah, Karthik.
All the My lord, my humble submission, my lord. Even if my lord national promotion is given to me, my lord, I will, my lord, satisfy, my lord. Because my lord, in all aspect, my lord, I have been, my lord, discriminated, my lord, without any, my lord, financial benefit. No, that's all. Deeply obliged.
देखिए हो गया ना ओके सर देखिए এটা was an textual aspect
Yes.
and so far as my case is concerned 2013 when they were rewarded when the direct recruitment took place out of the 6% petition number 5 and 7 they were only rewarded to the post but remaining were not even rewarded they continued at their officiating capacity in the post of ST engineer.
Even Mr. Sankya's client was not reverted. Who were not reverted?
Except 5 and 7.
17, 7, 13, that order.
Yes.
It does not include,
Others except 5 and 7. 5 and 7 were rewarded.
only 5 and 7 were reverted, not others.
Not others.
I also.
And in the reinstatement order of 2913, why were all names again given? 215?
No,
Your
there are others, my lord.
others.
In this 17/7/2013 order, only serial number 6 and 8 on the right hand side. They are the two appellants here, 5 and 7.
They were not reverted.
They were rewarded.
Oh, 5 and 7. Oh, for 5
Whose
and
name
7.
appear at serial number 6 and 8 here.
Okay, understood. Yes, Mr. Pani. Why in installment basis?
My lord,
Huh?
I will rely on the, my lord.
You have already,
Judgments, my lord, yes. In the
you have
last,
said initially, Mr. Mazumdar will take 15 minutes.
my lord,
We have passed. I think I don't know how long will it take.
no, my lord. Only the judgment, my lord, relied by my senior counsel K.N. Chaudhary, that other case, my lord.
NR Banerjee.
Yes.
You can give the citation. You can give the citation.
Give the judgment itself, my lord. Paragraph 10 of data also.
Citation.
It's my lord reflected in my lord's judgment. My lord.
NR Banerjee is where is NR Banerjee?
मालूम है
Where is NR Banerjee? This is director. K. Chauhan, Raja Mohan. NR Banerjee, yes. 1997 9 SCC, correct?
Yes, my lord.
वही मालूम है
Or you are equipped with yesterday's judgment.
Yes, my lord.
Certificate copy available.
My lord.
Itanagar is very fast.
Met to the notes.
Your
5 to 24 in both the redactions. Item
are 5 to
24.
in both Mazumdar and
Yes,
Sakya
yes.
in WA
28,
28 as well as 35.
35. WA 35 may be taken up first, because from the record I will show, they will appointed against direct recruit quota, there will no vacancies.
No, the initial officiation was not against a vacancy. Had there been a vacancy, there was a direct recruitment quota only.
Yes,
But later, the records which have been placed before us, it suggests, it indicates.
that is why, my lord. There was no records produced by the government. It is on the basis of the records I filed. The London single justice came to conclusion, these are RTI documents, come to conclusion that they could not substantiate it.
Where see your RTI documents?
Yes. My affidavit in opposition starts from my lord, page 258.
Which one?
At item 5. And my lord,
Since it's an appeal, I think the consolidated thing also includes your affidavit.
yes,
You can indicate the page number.
it is in 258, it starts, 258, item number 5, my lord.
258.
Yes,
No, you take the affidavit itself. The difference
Yes.
will be compilation and that affidavit separately not required.
281 would be relevant. Before that, my lord, I just wanted to point out, while under elder brother, Mr. Soikia was trying to show that there are only 13 electrical appointments. The power department comprises of 3 departments. Power. There is electrical branches, mechanical, and electronics and computers. They are not differentiated. Their seniority is also same. I'm just showing it for the purpose. There is no any difference. It doesn't mean anything. The career strength is counted as a whole.
So in the power
In the-
department,
yes.
it is not necessary that you are inducted as an electrical
Yes.
engineer only.
Yes.
Even a mechanical
Yes,
engineer,
60% is for electrical, 30 is for mechanical, and 10% is for,
department is the same.
yes. And the seniority is also maintained like that. My lord, kindly have a look. They try to differentiate it, that's why.
29.
My lord, will see serial number 16 is a computer. Then thereafter, the others are up to 20 is mechanical, 21 again electrical like this. 26 is a electronics and computer. They are a common category. So it is not that 13, only 13 were appointed or something like that. I will come. The recruitment rule itself provides, madam. Así ko lang.
Oh, what is this document which you have placed before us?
This is the memorandum dated 29 January
that-
2026,
what is
the
it
final
about?
seniority list of the grade of assistant engineers. This includes all our names, the appellants as well as the private respondents. I'm only showing it for the purpose that my lord, power department comprises of 3 branches. And they are not different, the common seniority list also. Because Mr. Soikia made a submission, that's why. Only 13 were appointed, not 20, that's why. If your lordship have kindly have page 21, 281 of the memorandum of appeal, item number 5. This is a file noting, my lord, supplied to us under the RTI Act. This is a file noting of 2011, my lord. May I read?
You are referring to WA 35, isn't it? WA.
Yes.
Yes.
With reference to the direction of the Secretary Power on 38 2011 in presence of unemployed youths, wherein he desires that the vacancies are to be placed, requisition to the Public Service Commission for conduct for recruitment process. In the light of this, the vacancy position has been worked out as under clear vacancy due to creation of unit and post 7 numbers. I will kindly note this is 2011. Before our requisition was sent. Vacancy due to retirement and death 5. Backlog 2. Vacancy due to promotion 9, total 23. In this regard, it is to inform that as per the recruitment rule, the post of assistant engineer has to be filled up 50% by promotion and balanced by direct recruitment. Since inception of Power Department, the government has appointed 82 assistant engineer through promotion and 65 assistant engineer through direct recruitment. A copy of list of AE appointed through direct recruitment process promotion is placed below for perusal, please. Hence, out of 23 number of posts, the vacancies, my lord, if we keep 17 numbers of posts for direct recruitment quota, the ratio comes to 50-50 out of 23. 6 left. That is, it comes to 82 posts for promotion and 82 through direct recruitment quota. And for the remaining 6 posts are to be divided equally for promotion quota and direct recruit quota. 6, my lord. This is noting of 2011. This is I was trying to point out all these statements in the affidavit of the government are in fact incorrect. If I was given, I could have shown that these were against anticipated vacancies. So this is their document, not mine. So, my lord, only 3 posts for direct recruits. If from the 6, after it becomes equal 82, my lord, 6 remains. So 3 has to go for promotion, 3 for direct recruits.
Now, what about the factual proposition first? That total vacancies are 23 numbers.
Yes.
So from where are you submitting that it is actually 6?
No, I'm reading this, madam.
No, that we have read, but how do
Yes.
you reconcile? First part says it's a tabular form.
Yes.
Clear vacancy due to creation of unit and post 7.
Yes.
Vacancy due to retirement that 5.
Yes.
Backlog 2.
Yes.
Vacancy due to promotion 9. Total
Yes.
23.
Yes.
Now the second paragraph is on the background,
Yes.
but how can you dispute the proposition that there are 23 vacancies were existing as on?
Yeah, 23 vacancies existing, my lord. Out of that, since there was only 65 direct recruitments, they wanted 17 to go for direct recruitment directly. That comes to 82. That leaves 6 posts. 3 for promotion, 3 for direct recruits. That is what it has been said here. May I read again?
No, I've read this.
Out of the 23 posts, since there have been 17 excess promotion,
From
they
the-
have
from
given
the-
17.
From the promotee quota.
Yes,
So the 17 will go there.
direct recruit.
So
6
6 will
remains.
remain.
Yes,
So this 6 has to be divided into 50-50.
yes. So that is what 20
So the
requisition.
quota of promotion will come to 3.
Yes. So that is how 17 plus 3, 20 was advertised. And I will show how the rest 3 promotion was filled up. So at that point of time, that is why the Lord Singhal categorically said again and again. Am I clear on this, my lord? 17 goes plus 3, 20. So that was advertised, my lord. At page 288, 20 posts. That is including, my lord, mechanical as well as electronics and computers. 20 posts, 17 plus 3 advertised. The result notification at page 290. 20 were, my lord, recommended for
You are at page 288,
290, my lord.
290.
288 is the advertisement
The
for recruiting 20 posts of assistant engineers,
direct recruitment.
direct recruitment, 17 plus 3 as per the file noting.
Yes,
That includes, my lord, electrical as well as mechanical as well as electronics and computers.
correct.
Yes.
Then,
Then 290 is the result notification where 20 has been filled up.
yes,
Then your lordship will kindly have page 299.
yes.
This is the initial appointment order of appellant 2 and 3. At serial number 3, your lordship will find the officiating appointments against the quota band for direct recruits. And as and when direct recruits are selected by Public Service Commission, their appointments shall automatically stand terminated.
This is the officiating of,
Appellant number 2 and appellant number 3.
subject to joining,
Oh, yes.
filling up of those posts
Yes,
in regular mode by direct.
direct recruits. This is in 2009, my lord.
But what about their, after the direct recruiter had joined, they were reverted in fact.
Yes.
Thereafter, another order of reinstatement with same date.
But fact remains there was no vacancy as on that at that point of time.
Then,
My lord has seen what the
Then
government has been doing.
no, the under what, well, see, you are contending that the fact that they had to be reverted
Yes,
and it was a conditional
yes,
engagement.
yes.
After reversion, they were again reinstated in the post. In under what vacancy?
Madam, we don't know, madam, but we'll see.
No, if there is
Even
no
initially,
vacancy,
2009, they have been giving, madam, even scale also, madam. That is how the government is working. But that does not take away the fact that 17 of 3 has gone for direct recruitment and only 3 remain for promotion. And how that 3 promotees were filled up, I will show, madam. This I am only showing for the purpose that they were under against the direct recruit quota. Page 301 is the initial appointment order of the appellant number 1. Here also direct against the direct recruit quota. My lord, kindly notice this is 2010,
which
and-
page?
page 301.
What is there?
This is the initial officiating appointment order of the appellant number 1 against the direct recruit quota. This is dated 16th of June 2010. I'm referring to the date because in 2011, the department says there has been excess 17 promotions. It is the department's own document.
This is appellant number 1.
Yes. 2 and 3 I have shown.
Yes.
303. This is dated 2nd of May 2011. The same year, the department says there were 17 excess promotion. And the order also says clearly against direct recruit quota. Appellant number 4, 5, and 6, they are a serial number 2, 4, and 6, my lord. This is dated 2nd of May 2011. So department itself in 2011 says there are 17 excess promotions. So here is the question of any vacancy, my lord. Now, my lord, will come to, this is an offer, the appointment letter is at page 309. Same serial numbers, Well, the serial numbers are different, 2, 4 and 6, 2, 4 and 5. Apparent number 4, 5 and 6.
What is this?
This is the appointment. Earlier was an offer for official appointment against direct recruit quota. This is 7th of July, my lord, 2011.
Appellant 4, 5, 6,
Yes,
appointment.
yes. On
Officiating
official
appointment.
basis against direct recruit quota.
Yes, how
Yes,
long
my
will
lord,
it
when we
take?
come back, my lord, I will show how these 3 promotions were filled up. My lord, kindly note, this is 2011, my lord, the same year, my lord, same month, when the file notice
How
was
has
met.
the government responded to your RTI?
Nothing, my lord. They have not said these are fake documents. That is why, my lord, it's unbelievable, my lord. And I can't understand when the government took a decision not to give them retrospective promotion. That is their whole demand. Now in the court, my lord is arguing in favor of the petitioners. I can't understand this. Government took a decision, my lord, not to give them.
Yes, things are getting complicated for Mr. Mazumdar and Sekia and Lampu.
No, I'll clarify.
I will show, my lord. The DPC manus means nothing.
We thought it would be over by 1 hour.
These are RTI documents and these are orders. I mean, they have not filed any reply saying that this document RTI, the petitioners, that these are fake, forced, and the order that I have annexed are not true. May I continue? But I had pointed out, my lord, the dates
Earlier.
when they were initially appointed on sitting basis. Now, your lordship may kindly have page 204. This is the minutes of the DPC held on 24/7/2012. I don't know, my lord, why on behalf of the appellant it was being continuously urged. DPC was only for the purpose of regularization of officiating promotions. All DPCs in Arunachal Pradesh are in that manner only. The 2022 also. Their officiating promotion was regularized, but with prospective effect from the date of DPC. Now, from what I will show is, as on 2008, my lord, there were no promotional vacancies. And up to 2011, when the file notings were met. I read, my lord, the DPC was informed that in the year 2008, based on the representation submitted by APSI graduate engineers, the state government had accorded one-time relaxation for conversion of 8 posts of assistant engineers meant for direct recruit quota to promotional quota, white order dated 17/3/2008. So, my lord, if there were promotional vacancies, what was the requirement for converting, my lord, direct recruit quotas into promotional vacancies, my lord? Apparently, there were no promotional vacancies because it is the senior most who were recommended, my lord. So now 8 were converted, my lord. Accordingly, the department considered officiating promotion of 8. They've given the names, my lord. Tajong Mesar, who was expired. Nida Makcha, Sri Bokar Basar, Moken Loya, Kabidiring, and Furpa Wangya. These are the 8 persons who were, my lord, recommended against the 8 converted posts. Now, my lord will kindly recall, there were 6 vacancies that is there, my lord. In 2011, file notice, your lordship will recall. 3 went to direct recruit and 3 was for promotion because this is in 2012, DPC recommendations. Now, those 3 vacancies for promotion, my lord, that was there, has been filled up by these 3 persons. The department has also given officiating promotion to 3 Js as A, namely Sri Obang Irang, Sri Punya Gambo, and Sri Janu Taing. So these 3 persons went against the 3 promotional vacancy.
Which 3 persons?
Sri Obang Irang at page 204. Just at the end of the, my lord, second paragraph, Obang Irang, namely Obang Irang. Then thereafter Sri Punyo Gambo and Sri Janu Taing. these three. And they were apparently senior to the older petitioners / appellants.
Paragraph 2 of 204.
204, my lord. The DPC was informed, my lord,
Yes.
yes.
Where are the names?
And the last part, my lord, right hand side, that last part,
Same page.
same page, my lord.
Obang
In this
Irang, yes.
paragraph itself, my lord.
Yes, 3.
Three J's, namely AE, Obang Irang, Punyo Gambo, and Janu Tang. These three were promoted against the three vacancies. My lord, kindly, this is 2012. So my lord also now kindly made a note again, my lord. The 8 post was converted on 17/3/2008. The lead appellant in item number 4 was given officiating promotion on 27/2/2008.
Item 4 means?
Item 4 means WA28, Marto Kamgo. Marto Kamgo was on 27/2/2008
27?
to 2008. In this read appeal, my lord, the appellant one on 16/6/2010.
In 15, what is the other one?
35.
35.
Yes. The appellant number 2 and 3 on 2/5/2011.
The first is,
16/6/2010.
yes,
Then 2 and 3 on 2/5/2011.
Yeah.
4, 5, and 6 on 7/7/2011. My lord, and seal the promotional post was converted only on 2008, 17/3. In 2011, the file noting says there were no promotional vacancies. There were excess promotion, my lord. Only after 23 post file vacancies, only 3 comes. Now, this Punyo Gambo and Sri Janu Tang, their appointments were challenged by the appellant in item number 6. He is admittedly the senior most. Now, this honorable court held, is a part of the record in his read appeal. This honorable court held, these are graduates, their qualifying length of service is lesser, they qualified earlier, so there's nothing wrong in their promotion. So at that point of time in 2012, there were no promotional vacancies. So that is why I go to the extent of submitting, my lord, if I may. The government has filed an incorrect affidavit, my lord. This is their documents, my lord, not mine. If on 17/3/2008, if there were promotional vacancies, what was the requirement of my lord converting 8 direct recruit vacancies into promotional vacancies? So in 2008, there were no vacancies. 2011, 3 arrows that were filled up by Sri Obang Irang, Punyo Gambo, and Janu Tang, who all are senior to the petitioners with appellants in item number 4 and 5. And Nani Pusang made a challenge that was also negated. So in the absence of any vacancy, my lord, where is the question of them being given retrospective promotion? So direct recruit 2 case does not apply, my lord. There may have been subsequent vacancies after 2012-13, my lord, we are not aware of that because there were direct recruitments in 2017 also. That we are not, but they cannot be placed above us. Because when our requisition was sent for direct recruitment, there were no vacancies, my lord. It is a record, record says so. They did not file any reply to my affidavit in opposition.
yes.
And all this, my lord, this 36 vacancies and all, my lord, this is something I cannot submit now, but it is apparently beyond the records, my lord, because if on 2000, my lord, you kindly see, my lord, kindly mark this, the 17/3/2008 is the conversion, 8 conversion. Now, in their affidavit, they say there were vacancies in 2006, 2007. How is this possible, my lord? They have given a chart, my lord will see, it says vacancy arose in 2006 because of this, My lord, this does not tell you in the records. And nothing was produced to substantiate that. That is why the learned single just held. How can you file an affidavit beyond the records? Because records were brought by me, my lord. Or RTI documents. This is the DPC, this is not disputed. In fact, they are relying on it. Clear, my lord, these 3 vacancies, my lord, that the 2011 file noting says has to be given for promotion has been filled up by Obang Irang, Punyo Gambu, and Janutang, my lord. So that is the factual position, my lord. So, situated thus, there being no vacancy as of 2012, by the time our recruitment process already started, there is no question of my lord giving them retrospective promotion. It was that simple case, my lord, that we were appointed against substantive promotional vacancies, including my lord Marto Kamgo in the writ petition. Now he's saying my vacancy was, appointment was against deputed vacancy, which is correct, in fact, correct. But in the writ petition, their pleading was, they all filed it together. We were appointed against substantive promotional vacancies. That is the pleadings. When I filed this affidavit in opposition, showing that no, this is not correct, they did not bother to even file a reply. My lord, since my lord, their only claim was that it has to be, my lord, they have to be given retrospective promotion. I would like to rely upon some judgments, my lord. I will not bother your lordships. My lord knows the recent trend, my lord, there cannot be any retrospective promotion, my lord, to the detriment of those who are already in service. I am first relying on 2022-6 SCC 105. Union of India and another versus Manpreet Singh Poonam. From paragraph 14 to 21. Paragraph 14 to 21. I will not read, but I'm just passing it on. Then, my lord, this was rated, as your lordship knows, in the Bihar State Electricity Board and others case. My lord, the Honorable Supreme Court has even gone to the extent of saying mere existence of vacancy does not give them any right for promotion. Right to be considered and right to be promoted is totally 2 different things.
In Manpreet, which paragraph are relying?
Which one, my lord?
Manpreet Singh?
Manpreet Singh, my lord, paragraph 14 to 21. In your paragraph 18, your lordship will find a mere existence of vacancy per se will not create the right in favor of an employee.
On that proposition.
Yes. That no retrospective promotion can be given to those who are not even born in the cadre, to the detriment of those who are already in the post.
And the Bihar case?
Bihar State Electricity Board, my lord, paragraph 21 to, my lord, 30. Here also the same proposition has been reiterated, my lord. Here, my lord, there are no vacancies. Even if there is a vacancy, my lord, that does not create any right in your favor. No retrospective promotion can be given.
Which one? Manpreet you have given already.
Manpreet given the state of Bihar.
Bihar also you have given.
Bihar also.
Bihar State Electricity Board versus Damodar.
Yes, yes.
You have just given.
Oh, I'm sorry. I'm sorry.
Given already. Okay, sir. Already given.
This is my lord, Akuri Sachindra Nath, paragraph 12. It is well settled that no person can be promoted with retrospective effect from a death when he was not born in a cadre so as to adversely affect others. Paragraph 12, my lord.
Yes.
Direct recruit case, my lord, is not applicable because there were no vacancies. Likewise, NR Banerjee is also not applicable because there are no vacancies. There's no question of holding DPC, and NR Banerjee was, my lord, the judgment was in the context that there was in the rules itself, my lord, that every year DPC has to be held. In fact, that has been distinguished by our honorable court, my lord, this bench.
Yes.
What a copy. It is paragraph 11. I'm just passing it on both the copies. Paragraph 11, madam.
What is it?
It says the NR Banerjee, my lord, it was there in the rules itself for holding DPC. This is Justice Jessica Roy's judgment. Paragraph 11. NR Banerjee is distinguished. Placing NR Banerjee into service, my lord, it was argued that DPC was required to be held in regular intervals. Paragraph 11. Madam. This was affirmed in appeal also.
What are these recruitment rules of 1984 and 1993?
My lord, that was in that case, my lord. There, the recruitment rule itself provides that the
No,
DPC
understood.
yes.
But what are these recruitment rules of 1984 and 1993?
But that is
There's a.
that is in respect of that post, my lord. In our case also, the recruitment rule does not provide that the regular DPC.
Which rules are applicable here?
The 1993 power service rules.
Can do we have a copy?
That is in Nani Pusang's case, my lord. Let them begin. Page number. In item number 7, my lord, at page 55.
There is no such requirement for the
No,
CP
no,
to have a
Yes.
yearly sitting.
yes.
Okay.
My lord, in the judgment, my lord, at page 167, the learned single judge has categorically held, but except for the stand taken, my lord, there is the records available are contrary to the stand in the affidavit in opposition. paragraph 34. And there is no rebuttal for any of the parties. I also point out one more thing, my lord. Since they took their stand in the affidavit, my lord, the learned single judge, in fact, gave the state liberty, my lord, to relook into the matter as per law. Now they have, the file was processed. That's why I wanted to, I was earlier saying, the file was processed, but now the Chief Secretary has said nothing doing. That is how the final seniority list has now been issued. The liberty was, that's all, man. So no way, absolutely no way. Obliged.
May I clarify the allegations that we have submitted incorrect affidavit, my lord? Only to that extent, my lord. Here, my lord will observe one thing, my lord. If my lord see their our documents in RTI reply, my lord, 281, my lord. 81. It say, my lord, after this, my lord, requisition, my lord, the ratio of 50-50 will be maintained, my lord. Now, suppose if that, first of all, my lord, two things, my lord. I beg to clarify, my lord, as both are our employee, my lord, I am not for any side, my lord. And these documents, my lord, if say, suppose the 50-50, if in one,
Page number?
282, my lord. 281, my lord. This is RTM, my lord. In 281, my lord.
Yes.
Now, if this, though this is our documents, my lord, if information this is to be taken in correct, my lord. Now, situation will be, my lord, after recruitment, my lord, the 50-50 receive, there will be no no post up, there will be post will be divided equally by two promoted in the this direct equity. There would be no vacant post, my lord. Now, my lord will observe one thing, my lord. Just after their appointment, my lord, this petitioner, my lord, FLN, where released from the released from their duty as a officer, my lord. But on the same day, my lord, my lord, they are again appointed, my lord. Now, if this information is correct, my lord, there would not be vacancy, my lord. How, my lord, they can be adjusted, my lord? So I purely considered, my lord, at that point of time, my lord, yes, my lord, this information, my lord, this record, my lord, was not happily verified, my lord. Therefore, my lord, we have worked out, my lord, in our affidavit, my lord. Now we have identified, my lord, in this document, my lord, the post is made 82, my lord. How post between 2 to 8, my lord, how post become vacant, my lord. That we have specified in our affidavit, my lord. How reason, my lord, due to date, due to promotion, my lord, we have specified. Now in those, the RTA documents obtained from RTA, my lord, that is not there, my lord. Now there is no reason, my lord, we should make incorrect, my lord, statement, my lord. Only that I want to clarify, my lord. We in our affidavit, my lord, will see, my lord, we have not only mentioned the vacancy, my lord, from where, my lord, vacancy areas, we have mentioned that, my lord, in our table, my lord. I do consider, my lord, in the DPC happened after 12, my lord, thereafter 22, my lord. Accordingly, no DPC was held, my lord. Therefore, my lord, somewhere, my lord, I consider, my lord, the record, my lord, and was not properly verified, happily not verified, my lord. That way, this happened, my lord. So, my lord, to correct, my lord, we have verified this and we try to go for review DPC, my lord. That was not accepted, my lord.
But you come to 283,
283, my lord.
288.
88, my lord.
No, 288 is the advertisement. 281 itself. See,
Yes, my
the
lord.
vacancy position as on 38/2011 has been stated to be 23.
My lord, my lord.
23 is, how is it 23? Because 17 posts were earlier already taken from the direct recruitment quota,
My lord.
and remaining 6, 3, 50 is 3. So 17 plus 3, so you have advertised on 23/11/2011. So this gives an indication regarding the number of vacancies, and this consideration was of 38/2011.
Yes, my lord, that's why, my lord, I barely considered, my lord, some, my lord, had record, my lord, has not happily verified or happily
It's
made.
not a question, happily. It's not a question, it's a question of factual determination.
Factual.
What expressions, what terms you have used in this, that is not of too much of a concern. We are concerned with the factual correctness.
Yes, my lord, that's true.
Factually, it does not appear that vacancies were there.
No, my lord, that's why, my lord, in our opinion, my lord, we have specified how this between 2008 to 20, how vacancy arise, my lord. Now, in this document, yes, this is our document, I consider, but there is no mention how this vacancy is calculated, my lord. Now, in our affidavit, my lord, will see, my lord, we have specified how those vacancy arise, my
When you
lord.
file your affidavit,
Our opinion, my lord, will see, start from page number.
when did you file?
It was filed on 15/5/24, my lord.
And Mr. Pangi, your
My affidavit,
affidavit,
30th of July,
30th of July, which year?
2024.
24.
Now,
Hmm?
our was filed earlier, my lord. Now, in says equally, my lord, he does not dispute our documents, this my information.
There's
my
no
lord.
documents to dispute.
Yeah. The submission was made that we did not dispute his this reply, my lord. But
Of course.
No, your explanation has come up in the way of an explanation in the affidavit,
Yes.
not by way means of a document.
no, my lord, that's why my lord, documents. If my lord see our
Where is your document?
my lord, documents also is maintained, my lord, specified in the last column, my lord. It's not that we have
No, where is
mentioned.
the document? It's a compilation, it's a
Yes,
tabular
compi-
form
yeah.
only for the purpose of projecting before this court.
No, my lord, that in the review DPC also hold those documents that was by this. This is part of the record in the DPC.
Page,
It start from, my lord.
which page?
177, my lord.
177.
My lord.
So this entire tabular form is a compilation from certain documents.
Yes, my lord.
Where are those documents?
That part that
It
where
will be a part of the affidavit
no, yes,
which
my lord.
somebody has drafted on the basis of certain information documents.
Hmm.
Where are those documents?
That was not part of the epidemic. But if my lord see, my lord, there is no reason that this is incorrect, my lord. If my lord see one also, my lord,
We are not saying incorrect.
no, my lord.
When a dispute has arisen before this court, you have to support the statement by documents.
my
We are
lord,
not saying that we are not raising any question of lack of bona fide. But we have to arrive at a truth by a fair means which is acceptable by all the parties.
my lord, but when we file this affidavit, my lord, there is no dispute as such, my lord. When we file this document, my lord, their affidavit opposition file later than us, my lord. When we file this, my lord, there is no dispute at all, my lord. That's the only thing I want to clarify, my lord.
And you see how you have verified paragraph 4. You have verified this paragraph 4 as being correct to as per the records. You need to back this, support this with the records. This cannot be personal information. This you can gather only from the records of the case.
Yeah.
We don't mind giving the information in a tabular form, convenient for the court to understand. But there has to be, the records are required to be with you. So normally, Mr. Parme, you say there is no reason to have the submissions of the government council in a matter of this nature when there is a factual dispute on the aspect of vacancy. But the situation here is slightly different. One party has the backing of certain information obtained under the RTI
Right.
in the form of documents.
Yeah.
And documents, the reasoning given are also appear to be acceptable. How the differentiation is made.
Right.
in the teeth of that, you have given certain other data that their vacancies has existed because of this promotion, this, that. Why this thing was not taken into consideration and the RTO was given in the year 2011? The RTO was given in 16 rather.
Yes.
It has given the DPC of 2011.
This report I need to check, my lord, maybe available here, my lord.
You check, but we'll close it.
And 2008, they have converted 8 promotional posts. That tallies with the 2011 file notings and the 3 promotions.
Yes, anything, Mr. We have heard
Yes,
it.
a short reply I'll give. Page 281. And if your lordship kindly turns to for a moment. Now, lordship will find a very opening word says this is an exercise undertaken by the officer, if at all correct, is based on a
Page?
page 281, my lord, on which my learned friend is relying on.
Yes.
With reference, it starts with,
Yes,
what,
yes.
with reference to the direction of the Secretary Power on 30th August 2011, in presence of unemployed youth, wherein he desires that vacancies are to be placed, requisition to Public Service Commission for conduct of direct recruitment process. This exercise was undertaken on the basis of a letter written by someone saying that kindly advertise the post, that there should be direct recruitment.
Hmm.
And not really for the purpose of ascertaining the actual position of the vacancy created through creation of post or through promotion made or through retirement or through superannuation. And secondly, lordship will find here also, it's a file noting, my lord. It's a one page of the file noting. Entire file noting is not there. The
It's there.
background is not there.
File notings are there, madam.
No.
It's there.
281 it starts. Where are the earlier pages of 281?
287 up to there.
No, it starts from 281. But what are the earlier pages? It starts directly from 281. It's not a letter.
Just a
281 is my paging.
Mr. Hanging,
Yeah.
where is the query to this?
Madam,
Where is the query to this?
query.
This, you had obtained under RTI.
Yes.
Where is the query?
Query I have not brought.
No, and you have, what did you ask
I will have to
for?
ask.
What did you ask for actually?
That info, I don't have. I will have to take instruction from
My lord may kindly turn to
No,
there.
this will have significance.
Yes.
What did you ask for?
Yes.
In what context this was given?
And my lord, the paragraph in
That I can do.
my lord, lordship will kindly see the paragraph 4 where they have mentioned about this document at page 260. 260.
They can dispute this now, my lord. Without even filing a reply to this.
260?
260 paragraph 4 on top, my lord.
Yes.
That the answering respondent begs to state that the Undersecretary Power, by letter dated 21/11/2011, sent a requisition to the Arunachal Pradesh Public Service Commission for filling up 22 posts of assistant engineer by way of direct recruitment. Be it stated herein that pursuant to a clarification sought by the APPSC to clarify that 20 posts are to be filled up by direct recruitment. It is also brought to the notice of this honorable court that there has been a backlog of 17 posts that was to be filled up by direct recruitment, inasmuch as there was excess promotion from the grade of junior engineer to the grade of assistant engineer, exceeding 50% meant for the promotion quota. Nothing is mentioned about this file noting. Straightway in the copy, my lord, a copy of the letter date 21/11 and the file notings. Even the respondent did not take any specific stand as to these file notings. This is my first submission, my lord, to what extent it's reliable. Now, lordship will kindly say another thing. The government affidavit which the government has filed, at page 177, my lord, they have given a data based on the date of promotion of those particular persons and the retirement, indicating that how the vacancy has arisen. And this is very important. Which one is to be believed? That this is also an affidavit on oath and giving the full data as to how the vacancy has arisen, whether by way of promotion, when. Date of occurrence is also there. In the table, they have given the names, my lord. Here I find, assuming, my lord, this document is correct, there they say vacancy due to promotion 9. Now, in this affidavit filed by the government giving the name of the person who was promoted, Lordship will find from page 178 onwards, 1, 2, 3, 1, 2, then page 183, 3, 4, 5, 6, 7, 8, 9, 10. So 10 vacancies arose due to promotion, whereas this document says only 9 vacancies due to promotion. Now, which one is to be believed? Not only this, my lord, this file noting does not indicate as to this vacancy position arising due to promotion during which period? Is it right from the beginning or during a particular period? It's not clear. How to believe this document? We are concerned with the vacancies arising between 2008 and 12. This document, although gives my lord, one aspect has to be seen. This is a file noting where it was mentioned that, see, total cadre strength is not mentioned here, but then 82 promotions were made, 65 direct recruitments were made. Thereafter, a decision has to be taken by the authority as to how much of promotion direct recruitment will have to be made so as to make it 50-50. But this file noting cannot take such decisions, my lord. Government will have to take a decision, taking a call on it. These are all file noting. These are not decisions. That by file noting, you say that now we'll make 20 recruitment and we will now equalize the proportion. They cannot take, these decisions are not decisions, these are file notings. Supreme Court in a very recent judgment said file notings are not decisions. This decision is not a decision. It's a file noting only. They cannot decide on their own and based on a letter written by someone that please make some direct recruitment. We are participating, we are anticipating. These are not decisions. Now, before your lordship, there are two documents. One is an affidavit filed by the government on oath saying that we are saying there are 36 vacancies and government has not simply mentioned 36, unlike this document at page 21. They have given the names of the persons who were promoted, retired, died, pursuant to which these vacancies arose. Now, this document is being disputed on the ground that there is a file noting that 2 ML 1-page document saying that there was a total of 23 numbers. So there is a dispute between two types of documents by the government. One on oath, the other one is a file noting, and the on oath is the respondent himself. Now, lordship, my submission will be in such circumstances, possibly one way we can conceive of is directing the authority to take into consideration all the vacancies available and then take a call as your lordship has done in the other judgment. This is one way I think is conceivable, man. Otherwise, it's not very clear. These file notings do not make things clear. And in the face of these specific names given of the persons who died, who were promoted, by virtue of which the vacancies arose. Now, here in this case, my lord, we are concerned with the actual number of vacancies arising during a particular period from 2008 to 2012. File notings on which reliance has been placed heavily do not show the vacancy position during what period. That period is not mentioned. And a decision to fill up the remaining, my lord, unfilled vacancy of direct recruitment cannot be taken in a file noting, my lord. Yes, 24/7 have been advertised subsequently, and then recruitment was made directly. That's a different thing. So based on that, my lord, an argument cannot be built that no, it is 23 and not 36. 36, the government has given a stand of 36. That has to be first disputed, and the respondent is not disputing that 36 data given by the government. They have also not disputed. They have not filed any affidavit against that. What will happen to that, my lord? That is also another thing. So that being the position, my lord, lordship will say, and my lord, one more instruction I have. During that period when this letter was written, that kindly advertise for direct recruitment, the vacancies which were being occupied by the officiating promotees were not shown, because they said that no, if these vacancies are advertised, how can we be subsequently regularized, because if the post goes. So those vacancies were not indicated in the file noting. This is my instruction, my lord. Just now over phone, my learned friend is.
No, but the subsequent letter of reversion,
My lord.
says that to accommodate the direct recruits, it is a different matter that you are reinstated or with the same date. But there are orders of reversion
My lord, there are orders of.
If those were not on those vacancies,
My lord, here,
and the initial,
my lord,
the
here,
initial induction was with a condition that when and ever the direct recruit should be appointed.
my lord, here, I'll possibly subject to correction, my lord. Against what vacancy they were initially appointed and under what condition they have worked till their regularization, possibly in my humble submission, subject to lordship consideration, will be irrelevant because today, when the person is claiming retrospective promotion, he has to show that vacancies were available, not because and my lord, he cannot be denied regularization only on the ground that initial appointment was a conditional, because the proposition number B of the directorate case says that if there are vacancies and if he has continued, and admittedly I have continued, I am entitled to promotion now. For the purpose of giving him the retrospective promotion, what is required is the availability of vacancy. Now, if the vacancies are available,
Mr. Mazumdar,
my lord,
the one question might arise.
my lord,
If there were vacancies available in your quota of
My-
promotion,
yes, ma'am.
why was there a requirement to put you in against the deputation as vacancy?
My lord, initially there may not have been any
So
available.
till what time?
My lord, that is why I am
Till
showing.
what time these vacancies were not
It-
available, and when
to-
suddenly when did the vacancies
My
were
lord,
available?
2008, that is why we are saying 2008 to 12 vacancies were there. Now the government is showing. That is why we are claiming that because much before 2008, we became entitled because we have completed the required number of qualifying service. That is why we are saying, my lord, we should be given retrospective promotion, if not from the date of first date, at least from when the vacancy has arisen. Today we are concerned, madam, subject to correction, madam. Today we are concerned with the availability of vacancy from a particular date so as to give us a retrospective promotion. That can be denied on the ground that your initial officiating promotion was conditional. Because there is no relation between the initial condition and his entitlement to retrospective promotion on the ground that he has continued and he is entitled to the benefit of the proposition number B of the direct recruit case, my lord. There is no relation between these two. That initially he worked not against a clear vacancy, but against an officiating against a DR quota. That possibly is not relevant today, my lord. Lordship will consider, my lord. Because what is required is availability of vacancy to give him retrospective promotion.
That's what.
And that availability may not be on the date when you are initially inducted.
Exactly, my lord.
Subsequently, but prior
Yes.
to 2012.
Exactly.
Okay,
That is my sense.
we'll consider, okay.
Just one thing, this file noting, my lord, what has been stated here, and subsequent events, my lord, the requisition sent, the advertisement, 20 posts, and the subsequent filling up, the DPC held on, my lord, 2012, where 8 converted posts were, my lord, filled up, including 3 vacancies that's reflected where clearly shows that this is a correct document. And as of 2012, there were no promotional vacancies.
Yes, please write, huh? The names. All the 3, huh? D. Mazumdar, Mr. Bora, please give the numbers.
My lord.
Who is appearing? Also heard the L permit. Then it's from the power department. You're also appearing, Ram? Are you a party here?
Oh, one only.
State Council, huh? Sri D. Panging, Learned Council,
5 to 24.
has appeared for the respondent numbers 5 to 24
More than
in both no, don't say both, in the WA, 28 of 24 and 35 of 24, because there's one W where you are not a respondent. Okay. Hearing is concluded, judgment is reserved.
Deeply obliged.
Yes.
Right.
Item 8.
Yes, Lordship. Lordship, copy was still not furnished.
None appears for the appellant on call. Full stop. Oh, not so full stop. Where is your name?
G Tayal.
G. Tai is present for the sole respondent. Full stop. Sri Tai has informed that copies of the memo appeal
Yes.
has not been furnished. Full stop. We have also noted that when the application for condonation of delay was considered, comma, the appellant / applicant was not present. Full stop. Para, be that as it may. In the interest of justice, another opportunity is granted and the matter is adjourned to be listed on when? On 23rd of February.
Leave alone.
Item number 9.
May it please your lordship.
Yes.
And it says jail appeal and it is listed for the first time. And my lord, the only copy of judgment has been filed before the Honorable High Court, my lord. So now the TCR is need to be called for. And later on, my lord, the condemnation and the memorandum appeal need to be prepared by the Legal Aid Council, my lord.
Is there any delay?
Yes, my lord, delay of 1,736 days, my lord.
We are required to have a legal aid council.
Yes, my lord, what my humble suggestion would be, my lord may call for the TCR because it's a statutory appeal. So after receipt of the TCR, my lord, may appoint the Legal Aid Council and accordingly they will prepare the memorandum of appeal as well as required application, my
We
lord.
can have the legal aid council appointed today. You have a list?
Yes, sir. My lord, quantum of sentence is in second last page, my lord, para 15 onward, my lord.
Please write. The present appeal has been registered on the basis of a letter dated 11 December 2025 issued by the Deputy Superintendent of Jail, Teju, District, Lohit District, enclosing thereby copy of the judgment and order dated so-and-so, passed in so-and-so, whereby the appellant has been convicted and sentenced to so-and-so. Please write from the judgment. Mr. Ate, you are the additional PP.
Yes, my lord.
We have also heard Sri T. Ate, the learned APP, Arunachal Pradesh. Para? Don't say para, Arunachal Pradesh, who has informed that from the judgment, it appears that there is a substantial delay for preferring the appeal. What's the para? Be that as it may, call for the trial court record, registry to do the needful and list this case on receipt of the records. Full stop. Subsequent orders for appointment of legal aid counsel for the purpose of preparing the memo of appeal along with application for condonation of delay, if required, would be passed.
Obliged, my lord.
Item number 10.
Yeah, my lord. This is a classic case, my lord.
Item 10 and 11, my lord, this is arising out of the same judgment. My lord.
10 and 11.
Yes, my lord.
Here, Mr. Soki, one you are a respondent, the other you are an appellant.
It's, in the writ petition, we were both respondents.
Okay.
Now the state has filed a separate appeal and the private respondent. I was for the private respondent in the writ petition. So I prefer the.
The state has also filed an appeal.
Yes, my lord. This is a classic case of file noting has been challenged, my lord. And the writ petition was challenged. In the writ petition, file noting was challenged, my lord. And it culminated in interference with the file noting, my lord.
Who is the petitioner?
Private respondent, my lord.
I had appeared for the petitioner, my lord. My lord, there is a caveat as well that needs to be.
Page 139,
For
my
the
lord.
first time.
Yes, my lord.
So we discharge the caveat.
My lord. My lord.
Where is the caveat, madam? Heard Sri P.D. Nair, Learned Counsel, for the caveator who has lodged this caveat qua a judgment and order is so and so passed in so and so. The caveat would be heard in the event this court proposes to pass any interim order. Caveat stands discharged. Okay, what is it?
My lord. Against the file noting, my lord. Under writ proceeding was, my lord, initiated, my lord.
And it was allowed.
Yes, my lord. So, my lord, from the first day onwards, my lord, we have been objecting on we have been placing on Santi Sports, my lord.
Now, what is the present position now? It's a something to do with cancellation of a contract.
Yes, my lord.
So what
And to be awarded to the private respondent, my lord, now here.
It has been awarded.
No, my lord.
No, it has not been
No,
awarded.
no, what is the present stage?
My lord, this
Otherwise, that when the interim order was passed by the learned single judge.
In the motion stage.
Yes, my
In the motion stage.
Yes.
On the same day, in fact, the LOI was already issued. I had submitted the performance guarantee, everything. But by that time, when it was done, we came to learn about this order. So it has stayed.
Now, presently,
That after that interim order, nothing has happened.
okay, we can propose to have the matter finally heard on a date when all of you are ready. Early date. We don't want a matter of public importance to be stalled because of a court's proceeding.
Madam.
At the same time, there is an order. Mr. Nair is armed with an order of the court.
Madam.
You are under a heavy burden to overcome this.
My lord.
Because there is also an order to award the contract in favor of the petitioner.
My lord.
My lord.
My lord.
So these orders are direction in nature, direction which are mandatory in nature.
Yeah.
So the aspect of contempt would also come in.
Yes, my lord. That is-
because of that, we are seeking interim, my lord.
What kind of interim?
Stay operation, stay of
Also
the
seeking for stay of the judgment.
judgment, my lord.
What is your, how do you make out a prima facie case?
My lord, page 139, file noting, my lord.
One,
The writ itself was not maintainable, my lord. The writ was initiated on the basis of file noting, my lord. Page 139, my lord.
Yes.
My lord, may see the note 2nd May 2025, my lord. This is
Okay, we'll hear it. We'll say that not required to give the work to him, but we'll have a date next week. Okay, there is no question of filing any pleadings.
yes.
Just give a
No.
date which is convenient to all of you.
My lord. When? Monday, Tuesday?
No, you are going on.
Mr. Picha?
Monday, my lord, 16th.
My lord.
Monday. Because there's an interim. Okay. Third. Mr. Picha, you appear as what?
Standing counsel RD, my lord.
RD.
Yes.
Third, Sri B. Picha, Learned Standing Counsel, RD, for the appellants in WA 20 of 2026, as well as Sri D. Suki, Learned Counsel for the appellant in WA 21 of 2026. Also heard Sri P. D. Nair, Learned Counsel for the respondent writ petitioner, who is on caveat. Full stop. Both the appeals have been preferred against the judgment and order dated so and so, passed in WPC so and so, whereby the writ petition has been allowed and the following directions have been passed. Please give the direction. Last paragraph. Okay. Para. Admit for hearing. Full stop. Since the subject matter involves a contract for construction
Supply of materials.
or supply of
Materials, my lord.
to whom?
Under
Material supply for supply and procurements of materials under the MG NREGA 2005-26, comma, early disposal of this appeal, early consideration of this appeal would be required, full stop, as agreed to by the learned counsel for the parties. List for consideration on
Monday.
16th.
Monday.
16th.
Monday.
Full stop. Till such time, comma, the part of the impugned judgment requiring grant of the contract to the petitioner respondent shall remain suspended.
My lord.
What else is there? What else? What
My
is
lord, only that, my lord, page 222, my lord. That's the operative one. The order was set aside, my lord.
However, this interim order is not, however, no interim order is passed qua the first direction.
My lord. My lord, could there be an observation that this will not be understood to award the work to the appellant in WPC and Appeal 21? My lord.
Setting aside, we are not,
My lord. My lord.
first direction, we are not
My lord. My lord.
challenging.
My lord.
We are not suspending.
My lord. Deeply obliged.
Item number 11.
11 after. 11 after.
11 is
11
together.
11 is
Together. 11 to who?
It's arising out of the same.
11 is okay. 11, 10 and
10, 11.
Same.
Past orders in 11.
Item number 12.
deeply obliged.
May I please your
Yes,
lordship?
Mr. Yes, why it's for orders? Why it's for orders, Mr. Notice issued
lord.
through registered postage result
Yes.
with respect of 1420 so and so is still awaited.
Yes. On the last 2-3 occasions, my lord, they took time to file affidavit. And matter relates to, my lord, challenge of a rule. So, my lord,
Who had taken time? Madam?
Lord,
you have
Standing
taken
Council
time.
Education Department. Standing Council
Council
Education
Jammu.
Department.
Where is
Tagum,
Mr. Jammu?
Tagum.
Tagum is there. Where is Mr. Tagum?
Tagum.
Tagum was around. Where is he? But what about the aspect of service of notice upon respondent numbers 14, 20, 21, 22, and 34?
Yes, but we have taken complete, my lord. Service is complete.
Lordship, due to some urgency, Standing Council is has left the premises now.
Okay, but what about the aspect of notice of service? This is a writ petition.
Yes, my lord.
Writ petition is
Challenging
challenging
the-
what?
Challenging the
Challenging?
my lord, validity of the rules, my lord.
Rules.
Initially, my lord, we filed a writ petition, then added rules, my lord. Initially, we filed a writ petition, my lord, challenging the very action of
Yes.
the authorities in retaining the posts which are created for the elementary education. Deputy Director of my lord, elementary education. Then on the day of hearing, they produced an amendment rule.
Mr. Broadcaster, can you serve these respondents dusty? Can you take
Yes, yes.
instructions from your client? Madam?
My lord,
you come to
as
this
per
side.
my instruction, my lord, those is,
You
as
come to
per
this
my
side, we cannot see.
instruction, those is service.
Can you take dusty service on the remaining respondents? No, this report is not there. Have you taken dusty?
Not dusty.
You've taken steps, but report is not there. We cannot ascertain whether they have been served or not. Can you serve dusty upon them? You take instructions,
No,
we are
according
here,
to
you
my
come back after 5 minutes. If you have a talk with your senior also, who is online, okay? Mr. Purkasta, I think the local council will be better placed to
My lord.
whether dusty is
My
possible.
lord.
You have a talk with your client, 5
My
minutes.
lord.
With,
My lord.
That is that part we can pass some orders. Okay.
Obligers.
Item number 13.
13 has been. PIL. This is also for orders. Why is it for orders?
Probably for my IM, my lord.
Affidavit in opposition filed by respondent on behalf of respondent same is placed on records. Vocal tone filed on 10/17. 11 to 17. 10 to 7. Okay. Who is appearing for 10 to 17?
My lord.
You are appearing?
Yes, I'm praying for 10 to 17.
You have
And
filed your
yes, I have already filed my.
Then we can have this
on the last-
for admission.
Yes, my lord. My lord, some specific order may be passed, my lord, because we are facing problem, my lord. These private respondents, my lord, they are agitating before us, my lord. What happened, the cause of the petitioner, my lord, the PIL, is that, my lord, the construction work has not been carried out in the geotech location, my lord. Yes, we have admitted it. In 3 locations, yes, we have shifted the place, my lord, due to the dispute with the landowners, my lord. Landowners first, initially, they given us the land. Now, after participating in the tender process, my lord, and not being awarded with the work, my lord, they have refused to give the land, my lord. Because of that, we have
How do
changed the
you resolve
location.
this?
Yes, my lord.
How do you resolve this? This
So
dispute,
we have constructed,
this dispute we have to raise if you are having a difficulty for allotment of the site because of objections made by the landowners. Mr. Modi, you are the landowners.
My
no,
lord.
no, he is the contractor.
No, I'm the contractor, my lord. So far, my lord, the work is cancelled, my lord.
You are the department.
Yes, my lord.
All the work has already completed, my lord.
Oh,
But the
okay.
payment has been,
Yes,
my
sir.
lord, held up. Despite
Due
of the
to
order,
pendency of this PIL, my lord, the bill of the private respondent has been held up, my lord, by the respondent number 3, my lord.
If the work has been completed, is there a restraint order?
No,
No,
my
my
lord, no.
Then
despite of the order passed by this honorable court on the 10 November 25, my lord, is still the respondent number 2 and the respondent 9 is, my lord, agitating that the court order is not clear.
3. Respondent number 3.
And that only on that ground, our payment has been held.
There is a rather an observation in your favor, Mr. Modi. 10/11/2025, Senate Council for the petitioner has prayed for restraining the authorities from releasing the contractor's bill.
My
In view of the materials available on record, this court is not inclined to do at this stage because as per the report available, no fault is attributable to the
Exactly,
particular
my
matter. So you can go ahead with the.
My lord,
My lord.
respondent number 3, Secretary Planning, my lord, Planning and Finance, my lord. He is interpreting this order separately, my lord. In otherwise, my lord.
Why are you seeking time?
My lord, actually, my senior is out of the station on medical.
Is it? Who is your senior?
M. Nibo.
Okay. A prayer for adjournment has been sought for on behalf of
Next
the
step. Go.
M. Nibu, learned counsel for the petitioner. Para. Also heard Sri R. Picha, learned standing counsel RD. Ms. Pangu for Learned State Council and Sri C. Modi, Learned Council for the response number
10 to 17.
10 to 17, who has informed that affidavit in opposition has been filed. Full stop. The Learned Council for the respondents, Sri Modi has however submitted that in spite of the works being completed, the bills have been withheld
By the respondent number 3,
by the respondent number 3 only on the ground of pendency of the present case. Full stop. We have been, the attention of this court has been drawn to the order dated 10/11/2025, wherein the prayer of the petitioner to restrain the authorities from releasing the contractor's bill has been declined. Full stop. We make it clear that pendency shall not be a bar, would not be a bar for releasing of the dues of the contractor in accordance with law.
Yes.
List after 4 weeks.
Item number,
I have filed one IA, my lord.
Item number?
Item number,
Same matter.
yes, my lord.
IA for?
IA for discharge of the, my lord, for recalling of the order dated 8/4/25, my lord, where the deputy director, joint director was directed to undertake verification, my lord.
Where do you agree by this?
My lord, that's because I have some medical problem, my lord. I have undertaken spondylitis surgery, my lord, and I'm carrying one platinum in my neck, my lord. I cannot undertake long journey, my lord. This Mugli Tagu, my lord, is the joint director, my lord. Applicant is the joint director. Page 13, para 8, my lord.
Then who will do the inquiry?
My lord, the deputy commissioner has already done the inquiry, my lord.
No,
It
there
is
is,
on record, my lord.
the court thought it fit that the joint director rural development R6 will cause the inquiry. Now who will do the inquiry? Somebody else has to do. We can consider your prayer, but this exercise has to be done by somebody else. Paragraph 8. Page 13. This particular officer has a problem we can
Yes, my lord.
consider, but who will do?
Officer in the district would be the best person, my lord. Deputy commissioner would be the best person, my lord. Even the deputy commissioner has already conducted the verification, my lord, through a committee, my lord.
Where
is-
is that report?
Report.
Have you annexed that report?
Yes, my lord.
Where page?
307, my lord.
Of?
My affidavit, my lord.
In the main writ petition.
Yeah, yes, my lord.
Date?
Yes. 307, my lord.
Date?
Date, my lord. 7 March 2025, my lord.
Heard. Yes, what do you say here?
Madam, I'm actually unaware of this case.
But let him respond. It will not be proper.
Yes, ma'am.
If, without issuing notice, it will not be proper.
Yes, yes, ma'am.
We'll do something. We'll protect your interest.
Yes, ma'am.
Heard. Sri B. Picha, Senate Council for the Standing Council RD, which is the applicant. No, RD. Who is this?
He is a joint director, my lord.
Applicant in the Sri B. Picha, Standing Council RD, who has moved this application on behalf of the applicant, who is stated to be the joint director. Within bracket response number 6.
Yes, ma'am.
And I don't say response number, joint director, who has been added as response number 6 in the connected PIL. Full stop. The application is for recalling of certain observation made in the order dated 8/4/2025. Full stop. It is contended that the applicant is having serious physical ailment.
Yes, my lord.
For which traveling may not be possible. He has also submitted that a detailed inquiry was made by the Deputy Commissioner
Yes, my lord.
through a committee,
Yes.
and this aspect could not be brought to the notice of this court when the PIL, was it PIL?
Yes, my lord.
PIL was moved. Was it a PIL or a
PIL, my lord.
PIL? PIL was moved. Full stop, para. Let notice be issued,
My lord.
enabling the opposite party writ petitioner to respond to the present application.
Yes, sir.
Full stop, para. Sri, your name?
T. Katu.
T. Kato, appearing on instruction of Sri M. Tagu. No, what is your name? M. Nibo. Prays for 2 weeks' time to file his response. Full stop, para. In the interest of justice, it is provided that the observation made in paragraph 8 of the order dated 8/4/2025 shall be kept in abeyance till further orders.
My lord. Obliged.
And what about has been Deputy Commissioner through a committee, and the said report has been placed on record in the affidavit in opposition filed in the PIL. Okay.
Item number 14.
My lord, here we will pay for some more time to file our affidavit. In fact,
What is this? What is appearing in person? What is this?
My lord, I am appearing in person, my lord. My lord, this concerns a particular tribe, my lord, where I belong to, my lord, the Yobin community, my lord, Yobin tribe. Now, the Yobin tribe has been constitutionally recognized as one of the scheduled tribe of the state, my lord. For want of mention of the specific name in the presidential order, my lord, there is, in spite, the government has issued a certificate, a caste certificate, my lord. But in spite of the certificate being issued to the members of the Yobin community, madam, there's lots of ambiguous, there's lots of misunderstanding, my lord. And some of the departments, my lord, does not recognize the certificates actually issued by the government. So what happened is that the government
What is
issued.
your prayer? What do you want?
My lord, the prayer is, my lord, I just take at page 10, my lord, page 10 of the prayer, my lord.
Central government, have you responded to this?
My lord, our instruction is very clear, my lord.
What is it?
It is the inclusive definitions wherein, my lord, it is not specifically required to be, my lord, added in the 16 major tribes, my lord. However, my lord, we have received the, my lord, the instruction and the parawise comment and affidavit will be filed shortly, my lord.
File it because these are issues which need to be sorted
yes, my lord. In fact, the government also is in active consideration to redress their
But
grievance.
in that presidential order, if the tribe is not specifically mentioned,
Yes, my lord.
will the members of the tribe get the benefit?
The difficulty is that, my lord.
Otherwise, anyone might say that we are also
inclusive clause, my lord.
Inclusive,
Wherein,
my lord,
all inhabitants of the state
indigenous.
will be included in the, my lord, the state list, my lord. Some are, my lord, admittedly, some tribes are not, my lord, mentioned
Then,
in the state
Mr.
tribe.
Ratan, you need to take steps and
My lord,
explicitly say what steps are you taking
my lord,
so that they do not have any.
my lord, in fact, as per the Honorable Supreme Court's judgment in the state of Maharashtra and versus Milan, there is a specific direction that all the scheduled tribes should be specifically mentioned in the
Presidential order.
presidential order. Now, here in the context of this state,
During the framing of the constitution, this
Yes, my
kind of a situation was not conceived of.
Yes.
Now taking somebody might take advantage, misuse that expression.
yes, my lord. So that's why active consideration how
So
to
in
address
case
the
this
grievance of
nature,
the
it would be the state to take the best
Yes.
call. If you can clarify.
Yes.
Yes, exactly, my lord. There is a correspondence from the
Okay.
ministry also, my lord.
Third, Sri
P. Yobin,
P.
my lord.
Yobin, P. Yobin, petitioner in person. Also heard Sri M. Andartan, learned AAG, as well as Ms. Sri M. Kato, learned Deputy SGI. You are also appearing. Who is it? Okay, what is your name? K? Okay. As well as K. Mena, appearing on instruction of Sri Eyapang Senior Counsel for the APPSC. Madam, you are also appearing, or you appear only in criminal matters? Okay, while the central government has filed the affidavit, comma,
No, my lord.
they're not filed.
Received the my lord, the instruction, parawise comment.
No, don't say anything. Both Sri Ratan, the learned AG, as well as Sri Kato, the learned deputy SGI, pray for and are granted 4 weeks time to file the affidavit. We fix a date, he's appearing in person.
My lord.
List on
9th of March, my lord, is the 4 weeks.
9th of March we
My
can
lord.
give. 9th or 11th. No, not 9th, 10th.
10th of
No,
March.
Tuesday, the
Yes.
Tuesday.
division bench. I think 10th.
10th, my lord.
10th. Okay.
Obliged, my lord.
Item number 15.
May I please, lordship?
15, Mr. Rama, what is this?
Yes, my lord, last occasion on 22 January 2026.
Paper book prepared.
Report was called for, my lord. Yes, I have received the paper book, my lord.
Okay, is there any private respondent here?
Yes,
You are appearing for private respondent?
yes, respondent number 2.
Then we can have it for hearing.
My lord, in my IA, my lord, last occasion, report was called from the jail authorities from Teju. Because, my lord, the accused having some serious element of the inside the custody since last many months, my lord.
We'll have it for hearing
So, my lord,
immediately.
report was
Paper
called.
book is there. We hear it next week.
lord-
Instead of concentrating on the IA, you get the entire appeal heard on Tuesday next. Private respondent is there, paper book is
My lord,
prepared.
just for treatment of the accused, a convicted person, my lord. So, my IA may be considered, my lord. So, hearing.
Mr. Rama, we are hearing the entire appeal on Tuesday next. Tuesday next.
Okay.
What is the ailment you are having?
My lord, accused having some bleeding from nose and mouth and anus. So, actual cause of the ailment is not detected.
What action have you taken, PP?
Yes, sir.
Why did you wear your band properly? Your band is hanging. Should not wear like this. Yeah, wear it properly, wear it tightly. You are a PP, you should represent the state, you are representing the state, should be smartly dressed. Yes, but what is your instruction on the IA?
There is a report from job.
There's a report. Is it 5th of February?
It was called on 22nd January.
There's a report of 5th of February. I think you're referring to that. 5th February. What is the medical?
I got some.
My lord, when accused was kept here in the Zero, he was also admitted here in the TRIMS more than weeks, my lord. So thereafter, he was transferred to district jail Teju, my lord. So similar problems are here in the Teju jail. So he's having required for further treatment, my lord. And inside the jail, his treatment could not be conducted, my lord. If suppose, my lord, person will alive, then he will definitely spend his remaining sentence. If he will not alive, so, my lord.
You
it is difficult.
provide necessary medical facilities to he is entitled to necessary medical facilities.
There is a medical board.
But in this board constitution examination, if you are spending unnecessary time, the health condition might deteriorate. So be alive to the situation and take immediate steps to provide him the necessary treatment. Okay?
I'll communicate.
Yes. When can you get back?
They are in the district hospital. No such facilities are available for the treatment of the.
So what do you want in the IA?
My lord, my prayer, my lord, at least, my lord, interim bail may be granted for further here after till hearing of the main petition, my lord.
What is the offense?
My lord, offense is section 376 IPC.
What is your
He
age?
was convicted for rigorous imprisonment 20 years.
What is your age?
My lord, I am about 45 years, my lord.
We'll have the matter heard Tuesday next. Tuesday next. Third, Sri N. Rama, Leonard Counsel for the appellant, who has also filed an application for bail on medical grounds, full stop para. Also heard your name? Yes, Leonard APP, who has submitted that a status report was called for, which has been given via the communication dated 5/2/2026. Full stop. Perusal of the same, which has been enclosed to the records, would show that the health condition of the petition of the appellant is to be looked into, is to be examined by a medical board. Full stop para. Be that as it may, we have also noted that the paper book has been prepared and the correspondent number 2 has also entered appearance through your name?
W. Kumram.
Through C. So para. In view of the above, interest of justice would require would be served if the entire appeal is heard expeditiously. Para. In view of the above, para, list this appeal for hearing on we'll have it on today's either 17th or 19th, whenever you say. If you say 17th or 19th. When?
Hello, as per convenience of the lordship.
Both are hearing, both are division Wednesdays.
Yes.
17th.
17, ma'am.
Much.
Item number 17.
Please, Your Lordship.
Which matter?
Item number 17, Lordship.
Paper book has been.
Yes, Lord.
Lordship, before the appellant started, Lordship, Lordship, I have misplaced my file, Lordship. So matter may be
here for whom?
I am for respondent number 2, Lordship.
Boxer matter.
Yes.
Boxer matter.
You can have another paper book if it's come from outside, so that you can.
Only for this matter, Lordship, and because it's behind the bar from more than last 6 years.
For tomorrow, Lordship. Tomorrow, definitely, Lordship, I will come.
Tomorrow, we may sit for this matter. No,
Lordship, I have marked some in my in my paper book, Lordship.
Lordship, I have no problem, Lordship, if tomorrow also, Lordship.
No, what is the, what are your grounds?
Item number 18.
Your Lordships, I'm appearing on behalf of Senior Counsel Mr. A. Apang, who is the amicus in the matter, and I have been instructed to submit that he may be released from the matter as amicus.
Okay. A prayer has been made by Miss
K. Lawyer, Your Lordship.
K. Lawyer on behalf of Sri A. Apang, Leonard Senior Counsel, who was appointed as amicus, to discharge him of the said burden as he is presently unwell.
Yes.
Could have also heard Sri K. Ate, Leonard APP, Arunachal Pradesh, para. In view of the aforesaid prayer, comma, the Sri Apang, the Leonard Senior Counsel, is discharged from the responsibility as an amicus in this case. This court accordingly appoints. Yes, please. You have a list.
Yes.
Amicus.
The list is there, madam.
You can suggest any name. Yes, any amicus present in the court. Criminal matters, amicus. Mr. You're there. Yes. They appoint Sri H. Lampur, no?
Yes.
Leonard, as Leonard Counsel as amicus. Amicus, let a copy of the paper book be served upon him and the matter be listed for hearing after 2 weeks.
All right, madam.
Pass over matter item number 12.
Item number 12. What was 12? Pass over.
My lord.
Yes.
My lord,
Yes,
we
yes,
have taken steps, madam. We have taken steps on. Kitya?
That we know, we have taken steps, but the service report is
Yes,
not there. So in that context, we are asking whether it will be agreeable or is it possible to serve Dusty upon 14, 20, 21, 22 and 34.
My lord, then if matter is otherwise urgent, you will take step, my lord. Dosi service. 14.
No, you are required to take instruction whether Dusty is possible. We do not know. who are
All
the
right, my
respond-
lord.
That
Yes,
is why
madam.
we had given no time.
Yes, yes.
You take
No, I could not-
you
I
take
could not
proper
contact my
instruction.
Yes,
You
madam.
will have this on Monday next or Tuesday next.
Monday.
You take
Monday,
instructions
Tuesday.
whether Dusty is possible, okay?
Monday.
Heard Sri A.K. Purkast, learned counsel for the petitioner. Footstop. Of who has appeared online, huh? Para. Office note dated 2/9/2026 has, however, reflects that service report upon the respond numbers 14, 20, 21, 22, and 34. 14, 20, 21, 22, and 34 are still awaited. Para. The learned counsel for the petitioner prays for some time to obtain instructions whether Dusty service would be a viable mode. Full stop, para. List on Tuesday next. 17.
Madam.
Okay, Mr. Purkast, Tuesday. Please take
Madam.
instructions. Whether
Get this matter posted on 25th of February. I've taken consent from all the parties,
18 and 19.
18 and 19.
you are for whom?
I'm for private resolution number 5.
Names are not shown?
Yes, I will filing my Wagla today.
Okay. 3. K. Saxena, learned counsel, has informed this court that he would appear for the private respondent,
One, five.
one
Single respondent, yes.
private respondent in these two cases and would file the wakalatnama shortly. He prays for some accommodation. Para. Also heard. 3. Your Lampu, you are appearing for the petitioner?
Yes, ma'am.
3. H. Lampu, learned counsel for the petitioner, comma. 3. T. Tagum. Oh, Tagum is not there. And 3. Mr. Kato, Mr. Kato, you're
No, my lord, I'm not.
Lampu for the petition. Para. As agreed to by the learned counsel for the parties. List on when?
25th
25th of?
February.
Okay, 25 too. I had same common order in 18 and 19. Yes.
Obliged.
Malad, may I mention, I'm sorry, Malad, today it is also fixed matter, Malad, item number 6, Malad.
Fixed.
Malad, as per the department instruction, Malad, the affidavits are ready, Malad. 3 weeks time may be granted, Malad, for filing affidavit, Malad.
How much time was granted to you earlier?
Malad, admittedly, Malad, there was a miscommunication, Malad. Now, Malad,
Item number 6.
Malad.
M. Kato, are
Malad.
you for?
Yes.
I thought a petitioner already like 7, 8 times, I think.
This will be the last opportunity.
Malad.
Yes.
Okay.
So,
3. M. Kato, learned counsel, has renewed, Deputy SGA has renewed his prayer for time to file affidavit in opposition. What is your name?
RDU.
Sri R. Duty, learned counsel for the petitioner, has raised serious objections by citing, by submitting that time was granted to the central government on many occasions to file affidavit in opposition. Para, considering the same, comma, a last chance is granted
Malad.
to the respondent to file the affidavit. Para, list on today's 10th. We'll have it on 2nd of March.
Malad.
2, 3. Yes.
And Malad, in item number, Malad, 17, Malad, hearing matter, Malad.
Yes,
Malad, the matter will not come up maybe, Malad, on paucity of time, Malad. So,
Yes.
consent has been
Said
taken.
you were there.
Yes, 16.
On a joint request made by the learned counsel for the parties,
Yes,
matter is adjourned to be listed on 16,
16 of this month.
16 too.
Well,
for
if-
hearing.
Deep obliged.
Item 17.
May I, my lord? My lord, I'd like to mention item number 10 on behalf of Mr. T. Patil. He has instructed me to make a prayer for listing of the matter on 17th. my lord.
Mr. Saxena?
Yes.
Okay. On a request made on behalf of the petitioner, matter is adjourned to be listed on 17 too. Mr. Modi,
My lord, item number 69 for the petitioner here, my lord. There will be paucity of the time today. So, my lord, this may be kindly listed tomorrow, my lord.
Modi, we had visited your hometown, Pasighat,
My lord.
and we met your cousin also, Amit Modi.
Oh, my lord. So, my lord, tomorrow, this 8 years old case.
Okay, when do you want?
Item, tomorrow, my lord.
Tomorrow?
My lord.
Item 16?
16.
Tomorrow, what is the matter about?
My lord, pertaining to the non-release of the MR bill.
What is measurement book? What is MRP?
My lord, this medical reimbursement.
How old are you? What is your age?
My lord, that I have already,
Been in service?
yes, no, already retired. During the pendency of this case, I've
Yes,
already retired.
department, who's there? Whose department?
My lord, the RWD department,
Tomorrow may not be possible. We'll have it on Monday.
my lord.
Monday.
Okay.
Paucity of time may not permit this matter to be taken up for hearing today. Para. As urgency has been expressed by Sri C. Modi, Learned Counsel for the petitioner, list for hearing on Monday next. Date, huh?
All right.
Yes, then.
Lordship, item number 7, this matter may be fixed for tomorrow, Lord. Yes.
Tomorrow is not possible. 25 matter.
And next date.
Monday.
Monday.
Okay.
And both 7 and 11.
7 and 11.
Yes.
On a request made by Sri T. Tapak, Learned Counsel for the petitioner, list on Monday.
My lord, item number 11, we need some more time to file the affidavit, my lordship.
Okay. They write in 7. 7 you have filed affidavit, madam?
7 already filed.
Okay. And
In 11.
11 you write, how it's Sri T. Tapak, Learned Counsel for the petitioner. Para. Ms. Wangmo, the Learned State Council, has however renewed her prayer for grant of time to enable filing of affidavit in
As a last chance.
Para. When? List on?
Particular
9th of March? You get enough time, madam. 9th March. 9th,
there is an interim order, Lord.
interim order passed earlier to continue
Status.
till the next date of listing.
My lord, I beg to mention item 5, my lord.
Yes.
This matter might take some time, my lord, so we may not be able to finish today. If my lord may be pleased to take it up on 9th of March, my lord.
9th of March.
My lord.
Who's for the other side, Mr. Kamdu?
I'm for private respondent.
Private,
Five,
yes.
4 and 5.
Jini are for 4 and 5. And Kamdu? And do you have any standing counsel for land management, madam?
Oh, yeah.
You are the, okay. He is praying for 9th of, is it, can we record as joint request?
My lord.
Can record as joint request by the party?
Joint request, my lord, because
Okay, on a joint request made by the Learned Counsel for the parties, matter is adjourned to be listed on 9th March.
my lord, deeply obliged.
Your Lordship may mention for the WPC number 416 for listed for tomorrow for withdrawal.
Withdrawal, okay.
Yes.
Item number 1.
Lordship, matter pertaining to the release of the petitioner from his place of posting. Transfer order was issued, but even after lapses of 10 months, he has not been released. Accordingly, writ petition was filed. This honorable.
Where is the order?
Directed Lordship. Phase number 14 to 17.
Where is the operative portion?
17 Lords. Para 7. Within 15 days, direction was issued to the respondent number 4, that is the principal, to release the petitioner within 15 days, Lords.
Yes. Principal has been made a party in this contempt.
Yes, Lords. He is contender number 2.
Who is number 1?
DDS, Deputy Director of.
But was there any?
You have submitted representation to the both, Lords.
No. Was respond number 1 given any direction?
No, no direction.
Then we will issue to respond number 2 at this.
Yeah, Lords.
Okay.
Lords.
Heard. Sri K. Lolan, learned counsel for the petitioner, who by means of this application has complained of willful and deliberate disobedience of an order dated 7/11/2025 passed in WPC to 3/28 of 2025, full stop, by the said order, comma, the present respondent number 2 was directed to release the petitioner from the government higher secondary school Nyapin within 15 days of receipt of the certified copy of the order, so as to enable him to join his new place of posting at Namsai. The learned counsel has also drawn the attention of this court to the communication, to the representation dated 11/11/2025 issued to the respondent number 2, whereby the order in question was communicated. Para issue notice. First up at this stage, notice is confined the respondent number 2 alone. Para, let steps be taken for service of notice upon the respondent number 2 by registered by speed post to daily steps within 2 working days.
Yes, sir. There's a small prayer, then name of respondent number 1 may be strike out, because tomorrow again there may be delay in the notice.
Not delay, we are only giving to respondent number 2. That will not delay the matter.
Yes.
He may not be required also. Today, if you strike it out, tomorrow if it is required, then again you'll have a problem.
Okay.
Item number 2.
Yes. Mr. Patil,
Yes.
what is it?
My lordship, please. Here the petitioner, presently residing at Hunters Hill, Sydney, Australia. She is serving there as co-director in the Institute of Center for Cultural Linguistic Diversity, Eastern Himalaya, University of Sydney, Australia. Now, the Arunachal Pradesh University has made an advertisement for the post of assistant professor, associate professor, and for professor. Now, on thing of this advertisement, she applied for the post of travel studies. When the scrutiny was done, she was found ineligible. For that, she came to the High Court. He approached the court by filing the petition number 447 of 2025. After the interference of this court, she was allowed to sit in the interview. Now,
Okay, we issue notice at this stage.
my lord, I am seeking for interim also. During the pendency of this case, there should not be any advertisement of new advertisement.
Are
for the
you
same
going for a new advertisement? If there is a new advertisement, you can participate in that. Why there should be an interim order?
Because here
cannot be a total
the
restraint.
interview was held.
Are you appearing for the university?
Yes, my lord.
Yes, what is the stage? Are you going for a fresh advertisement?
My lord, in this case is not maintainable, my lord.
Let them say.
Because interview was conducted on 15/9/2000, 22/9/2025, and result was declared on 30/9/2025. Any complaint, there has to be lodged before on or before 30. But after result has been declared, they came to this court by praying that there was illegalities.
That may not be a reason for on the question of maintainability or repetition. They can question it. But you may say that he had an avenue for redressal of the grievance, which has not been taken into account. Okay, we'll issue notice at this stage. Third, Sri M. Patil, Learned Senior Counsel, assisted by
T. Kumbo.
T. Kumbo. Your name is not there.
No, not here.
For the petitioner. Full stop. The grievance of the petitioner is with regard to a recruitment process for the post of professor.
Professor, and Maharaj
Department
also,
of Tribal Studies in the respondent one university. Full stop. The petitioner's application was earlier rejected by the respondent university, whereafter she had, she or she had approached this court by filing WPC 447 of 2025, whereby this court had directed for accepting her candidature and to issue a call letter.
Yes.
The petitioner alleges that the interview was conducted without adhering to the rules and with a preconceived intention, and the petitioner was not selected. Full stop. Para. The petitioner, and it is the contention of the petitioner that she was the sole candidate and had fulfilled all the requirements.
Yes.
And was fit from all aspects, and therefore the rejection is bad in law. Para. That notice be issued, returnable on 11th of March 2026. You appear for whom?
For 1 and 5.
You are standing counsel?
Yes, my lord.
What is your name?
T. Gadi.
Sri T. Gadi, Learned Standing Counsel, Arunachal Pradesh University, accepts notice on behalf of respondent 1 and 5, and rest?
Lordship, I've got 2, 3, and 6, Lordship.
You are State Counsel?
Lordship, on behalf of T. Lordship, Standing Counsel for Director of Higher Education.
What is your name?
K. Tabang.
K.
Tabang.
K. Tabang, Learned Counsel, appearing on instruction of Sri T. Jamu, Learned Standing Counsel Higher Education, accepts notice on behalf of the respondents 2,
3, and 6, Lordship.
2, 3, and 6. What about Chancellor? Chancellor?
My lord, this should be strike out, my lord. 2, 3, 4, and 6 is not necessary.
No, that will consider at a later stage. I think you can take for the Chancellor of the university.
Yes.
Sri Gadi, the Learned Standing Counsel, has, however, raised a preliminary objection questioning the maintainability of the petition. Full stop. Para. The same would be considered at an appropriate stage. There would be extra copies. Huh? Sri Patil, the Learned Counsel, Senior Counsel, prays for an interim order for staying any new recruitment process. Full stop. While this court is not inclined to pass a blanket interim order restraining such a process, it is provided that pendency of this case shall not be a bar for the petitioner to participation of the petitioner in the new recruitment process would be without prejudice. Can be done without prejudice to her present rights. Full stop. It is also directed that in case a new recruitment process is undertaken, no final orders of appointment be passed without taking leave of this court.
Yes.
Item number 3.
May I please?
One returnable date by 4 weeks session. 6. Yes.
Your Lordship, the case of the petitioners are there, Your Lordship. The petitioners are working as skilled craftsmanship under the Department of Textile and Handloom, Your Lordship. And their next promotion is craft instructor. And the department by order date 28/5/2025 convened a DPC, Your Lordship, for the promotion of consideration of promotion of 42 vacant posts, Your Lordship. And accordingly, 52 skilled craftsmen were prepared for the consideration to the promotion of craft instructor. However, Your Lordship, finally, Your Lordship, the promotion was given to the 42 skilled craftsmen to the post of craft instructor. However, the respondent number 6 to 11.
Why are you so late in coming to the court?
Your Lordship, we will show this document through RTA, Your Lordship. Why?
Your IBAM.
Yes, Your Lordship.
Third degree IBAM learned counsel for the petitioners who are aggrieved by the DPC recommendation made on 28/5/2025 for promotion to the post of
craft instructor.
Full stop. Amongst others, it has been contended that the recordings of the APARs were not communicated to the petitioner, which is in violation of the settled law. That notice be issued, returnable on, we give a date on 11th of March 2026. There are private respondents, Mr.
Yes, Your Lordship. Yes, 4 to 11.
Who will take, Madam Dasar?
Lordship, for 1 to 3.
Then State Council for 1, 2, and 3. Extra copies, 4, 5, 6. How many? 4 to 11.
4 to 11.
4 to 11. And by speed post to JD. Steps within 2 working days.
Your Lordship, there is one more challenge we have met. That as per the recruitment rule, Your Lordship, the craft instructor has to be promoted 100%. Your Lordship. By promotion, by seniority, Your Lordship. Seniority. But in this case, Your Lordship, our junior has been superseded as well.
Okay. It has also been contended that the criteria for such promotion, which is seniority, has been ignored.
Yes, sir. Much obliged.
Item number 4.
My lord, this petition was initiated, my lord, challenging the promotion of the private respondents with retrospective effect. Now, my lord, in the
Pleadings exchanged.
Pleadings are exchanged by 2015 matter. My lord, I'm praying for closing down the matter, my lord, with some observations. In the meantime, my lord, 3rd of July 2025, provisional seniority list has now been issued. I came on deputation, my lord.
Okay.
So where I'm placed as serial number 3.
Yes.
So my seniority has been counted from my date of appointment in the parent department.
Okay.
So that would take care of my grievance. But this is a provisional seniority list. So my lord may close the petition with the observation in the event, my lord, in the final seniority list.
Okay. Heard Sri D. Panging learned counsel for the petitioner. Also heard here for
T. Rolling on behalf of Father.
he is the standing counsel to tourism department.
Yes, Lordship.
T. Ronin.
Rolling.
Please give the name on behalf of Sri and Father, the standing counsel to tourism department. You are also there, madam.
Number 2.
Pangu, P. Pangu for State Council. This petition was instituted in the year 2015 with the grievance regarding the seniority.
Yes, ma'am.
Full stop. Sri Panging, the learned counsel, has, however, placed before this court a provisional seniority list of district tourism officers within bracket DTOs of the department dated 3/7/2025, as per which the date of his appointment in the parent department as 1/5/2007 has been taken into consideration. Full stop. It is submitted that the petitioner had joined the tourism department on deputation. Full stop. Para? In view of the above, comma, it is this writ petition is closed. Full stop. However, liberty is granted to the petitioner that in case the final graduation list does not take the is not in accordance with the provisional gradation list, the petitioner would have the petitioner can approach the appropriate court for redressal of his grievance.
Yes. My lord,
Para copy of the order dated 3/7/2025 is made part of the record.
all right.
Preparation stands closed.
Item number 8.
Eight.
Mayor, Lordship, in this item, Lordship, we were supposed to file our affidavit, additional affidavit, Lordship. We have filed.
Your file.
Yes.
You've got the copy?
Yes, Your Honor.
Yes, when can we have this?
Monday, my lord.
Monday?
Monday, my
Monday?
Monday.
Ms. Sangeeta, the Lalit State Council has informed this court that the additional affidavit has been filed. Full stop. The Learned Counsel for the petitioner has also acknowledged receipt of a copy of the same para list for admission on Monday.
Monday, my lord. Deeply appreciated.
Obliged.
Item number 9.
My lord, I am appearing on behalf of K.D. Sharma, the leading counsel for the petitioner. We have received the copy of affidavit in opposition filed by the respondent.
Okay.
Kindly grant us 2 weeks time to file the rejoinder.
Okay, what is your name?
O Pangam.
Heard Sri O. Pangam, Learned Counsel appearing on instruction of Sri K.D. Sharma for the petitioner. First up, also heard Ms. Basar, the Learned State Counsel, who has informed regarding filing of affidavit in opposition. Para. The Learned Counsel for the petitioner prays for and is granted 2 weeks time to file rejoinder affidavit.
Obliged.
List after 2 weeks.
Item number 12.
Yes, Mr. Bram.
Lordship, the power department has sent the pension document regards to the petitioner to the audit and pension. Lordship. Now, status has to be called for it.
Yes, madam.
Though we have filed our affidavit, Your Lordship, but the recent status report, Your Lordship, I have to.
Okay, you're seeking pension?
Yes, Your Lordship. And moreover, Your Lordship, for the quashing of the order whereby recovery has been, Your Lordship.
There's an interim order, there's some interim
Yes,
order.
Your Lordship, there is an interim order. Not
Okay. Heard Sri I. Bam, Learned Counsel for the petitioner who has submitted that as per information received, the power department has sent the proposal of the petitioner to the pension department.
Yes, Your Lordship, audit and pension.
Also heard Sri L. Parme, Learned Standing Counsel, Power Department, and Ms. Basar for the Learned State Council. Para. On the prayer of Ms. Basar, matter is adjourned by 2 weeks to enable her to obtain the up-to-date status regarding the consideration of the case of the petitioner. Interim order passed earlier to continue till the next date of listing. Okay, rest may not be possible. Orders, what orders there is? Here for which matter? 13. 13.
Item 13.
Why is it listed for orders?
Lordship,
Why is it listed for orders? Some steps or what?
Lordship, actually, this may refer to list order last of the Lordship.
Order dated communicated to the director NIT, Jote and the rest. Report. Yes, you are for whom?
Lordship, I mean,
Lordship.
Item number 14, 15.
14 and 15.
Yes, it's for implement only, Lordship.
No, 13 is, no.
Yes,
13 is not connected with 14.
Yeah, exactly.
Let us take up 13. Yes, 13 who is appearing?
Lordship, I have instruction to appear on behalf of the Institute Lordship, NIT Lordship. In this matter, actually, Lordship, Mr. G. Lolan was appeared earlier. His term was over, Lordship. Lordship, in this matter, I have got instruction that some BOG minutes and the Senate has already taken decision, Lordship. I need some, Lordship, 4 weeks time to file affidavit, Lordship, in this matter.
You are Sutradhar?
Yes, Lordship.
S. Sutradhar?
Yes, Lordship.
What is your Heard, your name is G Kato.
Yes, Lordship.
What is your name?
Lordship, G. Kato.
Heard to G Kato, learned counsel for the petitioners. Para 3S Sutradhar, learned counsel, has appeared online for the NIT and has paid for 3 weeks' time to
Lordship,
file the affidavit in opposition.
Lordship, let it be 2 weeks. Lordship, because of this delay, we are so aggrieved.
No, he is the new counsel.
Lordship, this is two reasons. They have already replaced 2 council. Despite that, they are not filing the reply.
Okay,
Lordship.
we'll give a date. 3 weeks. And don't say online and has paid for time to file the counter affidavit by submitting that he has entered appearance on behalf of the NIT newly. Full stop para. The said prayer has, however, been resisted by Sri Kato, the learned counsel for the petitioners, that on earlier occasion also
And
there were change of counsel, and yet the affidavit in opposition has not been filed. Para. Considering the above, a last opportunity, a final opportunity is granted to file the affidavit in opposition by the NIT, by the respondent NIT. Para. List on
26 Lordship.
Huh?
Let it be 26 Lordship.
26th. 26th is a holiday, I think.
Yes,
We'll have it on 2nd of March.
Lordship.
You file it, Mr. Sutradhar, 2nd March.
Yes, Lordship. Avla Lordship.
Yes. What is I?
Lordship, this is for implement, Lordship.
Item number 14.
Item number 14, it was at my instance, Lordship, this impugn notice, eviction notice was issued.
Okay.
It was at my instance, Lordship. There is a mass encroachment of the reserve, deeper reserve forest by the present petitioner as well as some other members from the villages. Under the pretext of
Yourself to be impleaded in the pending writ petition.
yes, Lordship. Because
Okay, yes.
Lordship, we'll file this
Objection.
objection, Lordship.
But if it is on his instance, how can
yes, Lordship.
exclude him?
Lordship, actually, Lordship, there is a miscommunication with this petitioner, Lordship. So we cannot.
Okay, we'll grant you a time.
Lordship, this may I, Lordship? Lordship, this was filed. In fact, they have received the notice on 3/11/2025 in the month of November, Lordship, 2025.
This
Now,
IA.
yes, Lordship. So in the while receiving the notice, they have also sought time for filing reply. And now, what it happened, Lordship, during the in the present pending writ petition, Lordship, there is a
Your T-Ligo. What is your name?
A Tatak, Lordship.
A Tatak. Heard Sri A Tatak, learned counsel for the applicant, who by means of this application has sought implement as response number 3 in the connected WPC, in the connected writ petition, full stop. Sri
K. Tabang, Lordship.
Sri K. Tabang, learned counsel for the opposite party writ petitioner, has however prayed for some time. Para. This court has however has noted that notice on this application was issued way back on 4/11/2025. And from the projection made in the IA, it appears that the applicant is the complainant
Yes.
on whose instance the eviction process was carried out, and there is an interim order.
Yes, Lordship.
Para. In view of the above, a final opportunity of a week is granted to the opposite party to file objection.
Lordship, the issue is, if Lordship, may-
1 week.
Lordship, the issue is now, since there is interim of eviction, interim order has been issued by this court, taking advantage of that, now they are, however, there was this court has directed to maintain status quo, but there is rampant construction activities going on, Lordship.
Week's time, list on Wednesday next.
Yes, Lordship.
Wednesday next. The Sri Tatak, na?
Lordship.
Learned Council has submitted that the interim order has been misused and constructions are being carried out. Full stop. The Ms. Who is appearing, Sagita or
Your Lordship, I'm appearing in.
Ms. Sagita?
I'm not in the IA, Your Lordship.
No, you are a state council.
Yes,
Yes.
Ms. Sagita, the Learned State Council is directed to obtain instructions as to whether the status quo order passed by this court has been maintained.
Lordship.
Okay.
Deeply obliged.
This is a very serious allegation.
Yes, Lordship. I have the videos and photographs also, Lordship.
Item number 15, same.
Deeply obliged. 15, Lordship, in item number 15,
Yes,
as respondent number 6, Lordship.
yes. Same.
Yes, Lordship. However,
case.
yes. Same case. However, I'm seeking impleadment as respondent number 6.
Six.
Yes.
Same, huh? You're also appearing in that case.
Lordship.
Okay, next
Deeply
Wednesday, we are fixing these matters.
Lordship. Deeply obliged.
Finish.